Good evening. The February 3rd, 2020 meeting of the Anne Arundel County Council is now in session. Please stand for the invocation and remain standing for the Pledge of Allegiance. Ms. Rodvian will lead.
Good evening, ladies and gentlemen. In the honor of the beginning of Black History Month, I thought of a unique invocation. This is I guess a poem that has been made into a song called Lift Every Voice and Sing, and it's sometimes known as the Black National Anthem. You would think ordinarily we would sing this, but sometimes when you sing, you don't pay attention to the words. So I'm going to read it. Lift every voice and sing, till earth and heaven ring. Ring with the harmonies of liberty. Let our rejoicing rise high as the listening skies. Let it resound loud as the rolling sea. Sing a song full of faith that the dark past has taught us. Sing a song full of the hope that the present has brought us. Facing the rising sun of our new day begun, let us march on till victory is won. Stony the road we trod, bitter the chastening rod, felt in the day that hope unborn had died. Yet with a steady beat, have not our weary feet come to the place on which our fathers sighed. We have come over a way that with tears has been watered. We have come treading our path through the blood of the slaughtered. Out from the gloomy past, till now we stand at last, where the white gleam of our star is cast. God of our weary years, God of our silent tears, thou who hast brought us thus far on the way, thou who hast by thy might led us into the light, keep us forever in the path, we pray. Lest our feet stray from the places, our God, where we met thee, lest our hearts, drunk with the wine of the world, we forget thee. Shadowed beneath the hand, may we forever stand, true to our God, true to our native land. And now the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Madam Secretary, please read the ethics statement.
The Ethics Commission has asked that I advise you that under certain circumstances, members of the public may qualify as lobbyists when they testify before the County Council. If so, the law requires that certain information be filed with the Ethics Commission. The Chairman of the Ethics Commission has asked that those present review the Ethics Commission information in the foyer of these chambers. If there are any questions about lobbying requirements, speakers should contact the Ethics Commission in the Heritage Office Complex on Riva Road.
Thank you. We will now invite members of the audience who have signed up before the meeting to address the council briefly on any subject not included in the printed agenda. Remarks will be limited to 2 minutes. We do have a few folks signed up. Will please come forward? I'm going to take a guess. Atris Gray? Oh. Okay, Chris Gray, Art Holt, Chrissy Holt, and Carmen Scarlupa. Please state your name and address for the record, and you have 2 minutes. There'll be a timer that will... Mr. Gray.
Good evening, council members. My name is Chris Gray. I am a retired architect planner, and I live in Lock Haven on the South River. Firstly, thank you for all that you do to make our county the best, and hopefully you're on a roll. We might even win the national contest for the best county. We certainly can be a leader in sustainability, environmental protection, and resiliency, and I hope that with your leadership we can achieve that. I applaud your approach and the administration's approach on being community engaged and your excellent listening ear. I think we can all agree that we need to use all of the tools available to us to preserve our threatened environment and address climate change. One of the most effective tools, I think, is the state and local public open space program, which has been responsible for many really great assets that we have. In my area alone, the Beverly Triton Park, the South River Farm Park, across the water from me, the original Quiet Waters Park, have all been able to take advantage of the funding from that program. One tract that you've probably been hearing about, maybe too much, is Glebe Heights Forest in my neighborhood. Lock Haven has been hit very hard, and this is just one more project that will clear cut 24 acres of the 45. And to put that in perspective, the 19 acres that was just added to Quiet Waters, 19 acres, this is 5 more acres than those 19 that will be cleared. A project that should not go forward, and we hope that OPZ will render their decision to reject this, after which I hope that you will provide your robust support for the public open space program and perhaps include a worthy project like Glebe Heights. Thank you.
Thank you, sir. Mr. Holt?
Hi, everybody. I'm happy to be here again, and I'm speaking in favor of a county council resolution. I'm Arthur Holt, I'm 8 Fisk Circle, Annapolis, in favor of a county council resolution in support of H.R. 1384, the Medicare for All Act of 2019. I had a meal with a stranger last Monday night. He had a bowl of cream of crab soup, and I had a slice of apple pie. I know his real name, but I think I will call him Love. Love had slept on the street the night before. He was cold and hungry and afraid about having to sleep on the street again. While we ate, we both drank tea. He cupped his mug to warm his hands and started drinking it too soon. He didn't even flinch as the hot liquid burned his lips and his tongue. Love seemed to be a little not all there. I think in the early stages of hypothermia, the mind slows down and you start to lose coherency. He said that he had been clean and sober for 7 years. I think it didn't really matter because there he was with no place to sleep and no prospects for the next night. Love was actually apologetic. He didn't want to hurt my situation. He didn't want me to spend money on him if it would take away money I needed for other things. I tried to find a place for him on the phone for about 45 minutes altogether. One call referred me to another agency, then one suggested another place. Love assured me that the last place suggested was only open when the temperature is below freezing. I am sure that his internal temperature was below normal. That's what happens when we are outside all the time in January and malnourished. I am telling you about this because Love didn't want anything special, just a warm meal and a place to stay. But there is a reason that he didn't have those things built into his life, and it might have something to do with untreated trauma. Many homeless people experience severe trauma during their lives before becoming homeless. When one suffers emotional trauma, it takes them away from those they love. Please pass a resolution in support of Medicare for All, which will treat people like that. Thank you.
Thank you, Mr. Holt. Ms. Holt?
It's Chrissy Holt from 8 Fisk Circle. Thank you for the opportunity to speak in behalf of a Medicare for All resolution. I'm going to start by invoking the words of Dr. Martin Luther King Jr. Of all the forms of inequality, injustice in healthcare is the most shocking and inhuman. Not inhumane. Inhumane means having some compassion. Inhuman means being actually cruel to other people. And last Sunday, we had a Medicare for All town hall. Many of you all didn't understand had a Medicare for All. So we had a town hall, and we brought in experts. Kindly, County Executive Stuart Pittman came and welcomed the attendees. We made the front page the next day, which we are excited about. And of course, our friend Phil was there to share his story about being denied the cancer medication that he wanted and needed from Care First. We've also had 2,500 views of our video, and we invite you to come look at our video at the Maryland Progressive Healthcare Coalition. The other thing that we want you to be considering is a news that broke by State Senator Joe Carter at the Medicare for All Town Hall when she talked about in Maryland, between 2009 and 2018, 140,000 lawsuits were filed by Maryland hospitals in an attempt to recover medical debt from their patients. These payments accounted for $240 million in medical debt lawsuits. 25 of these lawsuits go for wage and property garnishments against patients. We're talking about sick people. But more importantly, the numbers show that here in Anne Arundel County, these numbers are astounding. Between the years of 2009 and 2018, there was over $17 million in medical debt lawsuits. There are 1,210 cases of wage and property garnishment. Again, how much are these people being sued for? $1,430.
Thank you,
Medicare
Ms.
for
Holt.
All would clean this up. Thank you.
Ms. Scarlupa?
Hi, good afternoon or good evening. I'm Carmen Scarlupka. I'm at 5608 Bimini Court, Churchton, 20733. 2 weeks ago, I picked up an Anne Arundel County resident in Kent County. They were leaving detox, an inpatient detoxification medical facility that detoxes people from a substance use disorder. I drove that person to Charles County to go to rehab. Upon arriving at the rehab facility, it was determined that the medication used to detox the individual in Chestertown had left a residual chemical that made them ineligible to enter rehab. That was after 31 days in Chestertown. Now we're down in Charles County, so they could not be admitted. I had to pick up that person and then drive them to St. Mary's County to find yet another detox facility that would then accept them. They've been there for 2 weeks. 2 weeks to detox off of medication that was used to detox them off of the opiates that they were originally toxified with. This person doesn't drive. They've never held a driver's license. I got up at 4:30 in the morning in Churchton to drive to Chestertown to get them to Charles County by the 9 a.m. intake. This is medical care for a resident in Anne Arundel County, and realize this is all inpatient. Tomorrow she's going to be released and has to go from St. Mary's County up to Howard. Health care is a human right, folks. We all know this. And I'm asking for your support of H.R. 1384, Medicare for All. In 2017, Maryland declared a state of emergency in response to the opioid overdose and fatalities. U.S. Senator Ben Cardin declared gun violence a national health crisis in 2019.
Thank you. Thank you, this panel. This was all that we had signed up today. If there's anyone else who did not sign up and who wishes to speak, may please come up to the table and state your name and address for the record. Seeing no movement in the audience, the invitation to audience is now closed. Thank you. Is there any item any council member would like to place on the agenda?
Madam Chairwoman, I'd just like to add my name as a co-sponsor for Resolution 320 for the record. Thank you.
Thank you. May I have a motion that the partial reading of any bill, resolution, amendment to a bill or resolution or minutes constitutes the reading of the whole?
So moved.
Is there a second?
Second.
All in favor?
Aye.
The motion carries. Madam Secretary, please read the minutes of the January 21st, 2020 meeting.
The meeting was called to order by Chairman Allison Pickard at 7 p.m. and opened with a quote from Mother Teresa given by Ms. Fiedler. Mr. Prusky stated troops 804 and 192 would lead the Pledge of Allegiance.
Thank you. May I have a motion to approve the minutes of January 21st?
So moved.
Second.
All in favor?
Aye.
Any opposed? The motion carries. The minutes of the January 21st, 2020 meeting stand approved as read. Madam Secretary, please read the titles of any bills to be introduced this evening.
Bill number 720, an ordinance concerning zoning, other zoning districts, private golf course facilities.
Madam Secretary, please read the titles of any resolutions to be introduced this evening.
Resolution number 320, resolution approving the terms and conditions of the acquisition of real property consisting of approximately 37.5 more or less acres, known as 11127 Braggers Road in Odenton, Maryland, 21113 from Stechitas Investments, LLC, utilizing funds from the Advanced Land Acquisition Capital Project. Resolution number 420, resolution approving the declaration of certain unimproved county-owned property near Furnace Branch Road in Glen Burnie, Maryland as surplus property.
Thank you. Madam Secretary, please read the title of Bill number 8819 as amended.
Bill number 8819, an ordinance concerning finance, taxation, and budget, use or occupancy tax, transient lodging, short-term rentals.
Ms. Rodvian, this is your bill, and I believe the administration is making their way to the table.
Madam Chair, may I make a statement about the bill?
Yes, ma'am.
Thank you. So we've talked about this bill quite a bit at this point, so I won't go on for very long, but this is basically just a bill that would allow or create equity in the revenue that's collected from transient lodging across all types of transient lodging. Currently, hotels and bed and breakfasts are, we collect the hotel tax, but short-term rentals have not been subject to that tax, and this will put them on a level playing field. And there's been very little resistance among the short-term rental community, or actually none that I've heard. They see this as a fair way to participate in the short-term transient lodging business.
Does the administration like to respond?
Sure. Good evening, everyone. Pete Barron for the administration. Joining me at the table from the Office of Law is Ms. Kenny from Finance, Ms. Good, and Ms. McQuaid. We have a couple of folks in the audience if questions arise. I'll just reiterate what the sponsor said. The administration supports this bill. This will allow the county to collect revenue that we are losing. Airbnbs, VRBOs, these short-term rental platforms are new and are created a market that is folks coming here to visit from generally out of the county. In the past, we would have received this revenue from a hotel tax. There's no reason that we shouldn't take this revenue when folks come to visit the county and are using the same type of service. It's either we get this revenue from visitors or we're going to have to find it elsewhere. So we ask that you pass the bill.
Do you have any questions from the council? Ms. Hare?
Thank you, Madam Chairwoman. I just want to take a couple of seconds on this, and this is the tax portion of it, the tax piece of it, so I'll keep my comments to the revenue side. But I do think that we've heard sort of from state law that any revenue that comes in from this, 70% of it goes to sort of Visit Annapolis or the
No, it's 17%.
Okay, and
Not 70.
And 3% goes to the
arts.
Arts Council, right? Okay, so the county, in terms of, we're not getting all of this revenue, we're getting a portion of it.
Correct.
Right, okay.
And Visit Annapolis and Visit Arundel are services that help attract businesses and visitors to the communities, and the arts funding, I think you could make a pretty strong argument that it enriches the lives of our community.
Sure. And I think we've heard that we need to hire additional personnel to administer this. I think somebody said half a full-time equivalent. Is that accurate?
Refer to finance.
Yeah, hi, Karen McQuaid, Controller. Right now, we're going to try to absorb it. It depends on the registration at this point, so we, may have to in the future, but right now, we're going to just try to absorb it.
Okay, because I had asked, I believe actually our auditor had given us some information. I had asked her sort of how neighboring counties do, and I don't believe that with the short-term rentals, this has been looked at as really a revenue generator. It's roughly neutral, is what I'm understanding from neighboring counties. Is that accurate?
We got some information from Montgomery County,
Okay.
and they said they're revenue positive.
They are revenue positive. Did they say how much?
No, they wouldn't give any more information other than that.
Okay. The reason I say all this, I'm concerned a little bit in terms of creating equity between what I view as sort of really big corporations, the Marriotts and the Hiltons of the world, and the individual family who might have a house that they're a little bit underwater on that they rent. I don't know that that's necessarily the equity I want to create in terms of tacking on an extra tax and making them file a monthly report and kind of add all of this extra into their life, particularly if it's really probably not that much revenue for the county. We do benefit a lot from people who come here and visit and spend money at our stores and money at our restaurants and bring their outside dollars here. And I'm not necessarily sure that adding a 7% tax to the individual who might own a rental property is really a beneficial way for us to try and generate a few extra bucks.
So if I can just respond and sort of one thing, the person that comes and visits pays that, and both the two big platforms collect it per an agreement that we could strike. So it's done through the platform, and it's sort of baked into the trip cost.
Certainly, but the homeowner obviously sets their rates on a basis that they're trying to have a playing field where they can rent their property. An additional tax absolutely, I think, makes a difference in what they may set their price at or what they may not set their price at. And I believe there is language in here that if the platform, for whatever reason, doesn't collect it or things, I mean, there is a burden on the homeowner to make sure that any money is collected, and they do have to file these monthly reports. I think about doing my taxes and how much I would not enjoy filing a monthly report with the county. We don't really know exactly how much information will be required on a monthly basis, but I see it as burdensome, and I don't see enough of an upside for the county that I think this tax portion makes sense.
Ms. Radvian.
Just to respond, thank you, Madam Chair, to respond to my colleagues' concerns, one of the biggest players in the market locally is actually small business-owned bed and breakfasts who currently are complying with this. And so right now, those businesses are suffering in that they have to, they have to meet certain regulatory requirements. They have to collect the tax. And so right now, these Airbnbs are, given an advantage that's, actually giving them an unfair playing field with some very small businesses. This is not just about, I don't know, Hilton International or whatever. There's some very small businesses, local businesses that are an important part of our economy that are suffering from the lack of this equity. So again, it's paid by the visitor. It's not paid by and I understand your point about setting the rate, but it is not something that's paid by the property owner themselves. And as far as I know, I haven't received any pushback on that at all from the property owners. In fact, I've heard several property owners say that they think this is a perfectly fair way for them to participate in this overall market.
Seeing no other comments from my colleagues, we'll open up the public hearing. Remarks will be limited to 2 minutes. I don't currently have anyone signed up on 8819. Seeing no movement from the audience, we'll close the public hearing. Oh, we do? Oh, okay. Excuse me. Thank you. Please state your name and address for the record, and then you have 2 minutes.
Dan Tootle, Severna Park, 108 Escutin Road. I really have a question for the committee on this particular bill, and it's behalf of the many Anne Arundel residents who only rent their homes out one time a year, and that's during June week, attendant to a U.S. Naval Academy graduation. And now there's considerable revenue that comes from those rentals, but it's only a one time a year that it takes place. How does this bill apply to those homeowners who only rent their homes out for that 1 week of the year?
I'll respond to that if that's all right. Is this appropriate?
Go ahead, Ms. Radvian.
Oh, okay, then I'll just explain that this bill only applies to properties that are listed on internet platforms like Airbnb and VRBO and similar type platforms. And the finance office actually has the option of allowing less frequent filings if they realize, for example, that someone is only renting their property out during, induction week in June, for example. So they can minimize the filing requirements to accommodate folks that are really doing this just on a once-a-year basis.
Yes, I do know that the homeowners who do this go through a central booking arrangement to let their homes known to be available for this. So it's not exactly an Airbnb situation, but the homes are advertised for use.
Thank you, sir.
Thank you.
Yes, ma'am.
Hi, my name's Claire Corcoran. I'm from Hillsmere Shores. I'm on the board of directors, and I'm the chair of the zoning committee in our community. We do support this bill. We see it as helpful to our community because we have had a problem with investors, a lot of investors buying properties and turning them into hotels, essentially. That is our primary concern, is not what the gentleman was talking about, which is your resident who lives there and occasionally rents out for special, the boat show, commissioning week, whatever. Our larger concern is that we have now absentee owners, investors who've bought properties and basically are just doing nothing but renting them out. And they're doing it on multiple properties. Some of them will do them on the hosting sites. Some have other ways of advertising. I was looking at I would just ask you to maybe discuss the amendment, the language that you have regarding what a host is or is not. The initial one that I read, which made us very happy when I discussed it at our board meeting, said that a host must be an individual and not a corporation and whatever. Now the language has been included, LLCs, partnerships, what have you. And I think what you're trying to say here is that if someone is a member of any of those things, each time they have a property, it will be considered, because it says only two, right? You can only own two. My concern is, knowing how some of these things work, is if you ever go under a business entity search, there's very easy ways to hide who owns property. And, an LLC or any other partnership can have a resident agent, and good luck trying to find that person unless you're going to start parsing through all their tax returns and the pass-throughs and what have you. That is a concern. We don't want to see more than two properties owned by any individual entity. What this language here, I can see ABC, LLC, XYZ, partnership, and it could all be the same person.
Thank you. Thank you so much. And just so you understand, that amendment is on for the next bill. That's not related to 8819.
Okay.
So I'm going to do go ahead. I'm going to do a last call for 8819. Okay. We're good?
Madam Chair, could I just clarify?
Sure.
That it's the partner bill, so these two bills are working on the same issue. So the amendment that is going to be discussed tonight is for the partner bill.
Which number is that?
8919.
Thank you.
But thank you for your comments.
The public hearing for Bill 8819 is now closed. Madam Secretary, please read the title of Bill number 8819 as amended.
Bill number 8819, an ordinance concerning finance, taxation, and budget use or occupancy tax.
Do I have any further questions or comments from my colleagues? Mr. Pruski? No?
Ready to call the question.
Oh, great. Madam Secretary, please call the roll on Bill number 8819 as amended.
Ms. Hare?
Nay.
Ms. Lacy?
Aye.
Mr. Volke?
Nay.
Mr. Pruski?
Aye.
Ms. Fiedler?
Nay.
Ms. Rodvian?
Aye.
Ms. Pickard?
Aye.
5 in the affirmative, 3 in the negative. Bill number 8819 as amended is passed.
Point of order. It was 4 in the affirmative.
My apologies. 4 in the affirmative, 3 in the negative. Bill number 8819 as amended is passed.
Thank you. Madam Secretary, please read the title of Bill Number 8919 as amended.
Bill number 8919, an ordinance concerning licenses and registrations zoning short-term residential rentals.
As stated, this is the companion bill. Ms. Rodvian?
Thank you, Madam Chair. So the aim of this bill is to really begin to get a hold on how many of these are operating in our county, to have some accountability by having them register, just so we can identify them. And as mentioned in one of actually my constituents' testimony, to put a limit on 2 per individual person. Across the county, we have a very tight housing market, and it's especially tight when it comes to affordable housing. And if we are allowing investors to come and buy up properties that indeed are more lucrative as sort of as quasi-hotels through the short-term rental market, then we are putting a squeeze on an already very tight housing market. And so I urge you to pass this bill in its current form.
Would the administration like to weigh in?
Happy to. Pete Barron with the administration. Joining me at the table is Ms. Kenny, Mr. Bryant, and Mr. Deck from INP. As was mentioned, this is the companion bill to the previous bill. We've discussed this at length. I think it's important for some basic regulatory activity to happen with these. These are usually homes in communities, so it's we think a well-balanced approach to making sure there's some check on these types of rentals.
Do I have any questions or comments from my colleagues? We'll now open the public hearing. Remarks will be limited to 2 minutes. I do have 3 individuals signed up: Mr. Brian Riddle, Ms. Susan Margulies, and Claire Corcoran. Please come forward. You have 2 minutes. State your name and address for the record. Mr. Riddle?
Good evening, Council. I appreciate the opportunity to share my thoughts. I have several concerns with Bill 8919 that are problematic. I generally support the concept of the rules that provide safeguards and regulations for renters who are renting short-term, and the funding that was just passed by way of taxation for local programs. However, I do not support the county regulating short-term rentals by means of ownership, though through a personal or entity ownership. While I personally do not own any, nor do I have the intention of owning a short-term rental, if I choose to do so in this county, I don't feel the county should be picking winners or losers by dictating the means in which they own their properties. Standard operating procedure for someone who wanted to separate their personal liability from their investment would create an entity as a barrier of protection by not allowing property owners to protect their personal finances and forcing them to intertwine them. The county would be an enabling detriment to its citizens. Furthermore, the county should pass bills, should the county pass the bill as is without allowing business entities to own short-term rentals and regulating the number of properties which they can own, the county is choosing corporations like hotels as winners and its citizens are losers in the bill. I encourage this council to adopt an amendment to rectify the unintended consequences I'm sure this council is not intending to impose. I'd also like to say I do live in a community that struggles with short-term rentals, and I think that the intentions of the bill, Ms. Robbian's bill, I think that we as residents do struggle with the unintended consequences, but this bill is not the solution. I think there's a distinction between nightly rentals and short-term rentals. In my case, we have a 10,000 square foot home adjacent to mine, and they rent the home as a nightly rental, and it is truly problematic. But if that property owner chooses to rent their home or another home or other homes in the county, it's not going to correct the problem. Thank you.
Thank you, sir. Ms. Margulies?
Thank you very much for the opportunity to speak. My name is Susan Margulies. I live at 113 Conduit Street. I'm also the co-admin for the Support Annapolis STVR group, and Within that community, I speak on behalf of little Airbnbs, people that just rent rooms in their homes. And we are so grateful to Ms. Rodvian for the definition of a short-term rental, for taking the definition of a short-term rental from Baltimore City Code. In doing that, she has spared Craigslist. She has spared roommates.com. She spared word of mouth. She spared church bulletin boards. She has allowed that transitional pipeline of housing that local people offer for local people to help with their local lives, and we are so grateful for that. We also recognize that this bill is consistent with the nationwide standard and that Ms. Rodvian has stripped the registration process down probably as far as it could go, and we are so grateful that she has thought of us people just renting a room in our homes, widowers, retirees, single homeowners, and we're deeply grateful for Ms. Hare's comments. We think that there may be some bumps in the road with this bill, but it's just so much better than other bills out there, and we're just grateful for the courtesy and the thought and the care that you've put in defining things and in trying to make it as easy as possible on people like us who are not business people. We are not business people. We're just trying to get by, and we're grateful, and Little Airbnb by and large supports this bill. Thank you.
Thank you. Ms. Corcoran?
My main concern I addressed earlier regarding the number of homes in our community that might get under the wire because of how they title themselves. This gentleman has a point. People who are making money generally do want to protect their funds and not commingle, and so they will set up LLCs and other types of partnerships. And on the other hand, we have plenty of people like this lady in our community who also just, kind of small mom and pop kind of thing, and we want to support that in our community. Hillsmere is 1,200 homes. It's one of the largest subdivisions in the county, and we have no problem with what you're talking about. What we do have a problem with is the people who are coming in and licensing themselves, unfortunately, and buying up multiple properties and being able to hide them, play a shell game, essentially, which then creates a situation where we find people who have bragged, actually, on websites about how many properties they own in our community. There'll be a complete list of everything they own. So my bigger concern is just the language that you adopt, and that you find a way that you can actually track these people so that we know that it's not just, Jones LLC and Smith LLC and Thompson LLC and, Tom, Dick, and Harry LLC, and it's all the same guy, but they all have different resident agents. They have different addresses that this stuff is sent to. It gets very convoluted, in terms of, like I said, you'd have to go through the pass-through entities and taxing to figure out who's really at the bottom of it. So that's our larger concern, is seeing our community become kind of a default cheapo hotel neighborhood, as opposed to just people who do want to rent out occasionally and make a few bucks and not run a hotel. So.
Thank you. So those were the only folks signed up. Is there anyone else? Y'all can dismissed. This is the last call for the invitation to audience for Bill 8919. State your name and address for the record.
Hi, yes, my name is Anna Cheney. I'm at 5801 Brookswoods Road in Lothian, Maryland. I'm here to let you know and make a request to let you know first that I support the safeguarding of any short-term rentals. I think that's very appropriate, and anybody would probably want that who is going to be renting them and or providing them for rent. I also believe that the taxation is perfectly fine. And I know that the tourism in our county is a huge part of our economy, and I think that we need to encourage that in all parts of our county. We know that it doesn't require infrastructure such as schools schools, extra hospitals. The road doesn't need to be widened or greatened because of short-term visitors. And I think we all know that it funds a lot of the projects that we do in Annapolis and Anne Arundel County. So my request is that you do support the amendment that I'm reading, because I don't think that we should be regulating how a person, an individual, owns their property, whether it's in an LLC or a corporation. I think that the safeguards are what we're looking for. I think that I understand some of the concerns that I've heard tonight, and I think that there are other better ways of doing that. I think that it's a legal issue, and that we shouldn't be dictating how any individual owns any property in this county. So thank you very much. I appreciate the bill, and I ask that you support the amendment.
Thank you. The public hearing on Bill 8919 as amended is now closed. Madam Secretary, please read the title of Bill number 8919 as amended.
Bill number 8919, an ordinance concerning licenses and registrations, zoning, short-term residential rentals.
Is there any further discussion? We do have 2, now 3 additional amendments. Madam Secretary, please read amendment number 10.
Amendment number 10. This amendment allows a host to be an individual, corporation, partnership, limited liability partnership, limited liability company, or other business entity, and requires that any individual or business entity with a financial interest in a host also be considered a registrant for the purposes of counting the number of registered short-term residential rentals.
Is there a motion to adopt?
So moved.
Is there a second?
Second.
This is Ms. Hare and Ms. Lacey's amendment. Ms. Hare?
Sure. Thank you, Madam Chairman. So this is just to address, we've heard a little bit of the concerns tonight about how one owns a piece of property. This is not meant to increase the number that has otherwise been placed in the bill as a limit on the number of properties, but there are lots of legitimate reasons why someone might choose to own their property in an LLC for liability, estate planning, what have you. And I do think we should encourage tourism, and I don't think we should be in the business of saying that only people who own a home individually and have the means to do it that way should be allowed to have a short-term rental. I am cognizant of the concern that there could be pass-through entities. I think that we have addressed that by including in here that it counts as the registration for any other business entity with an ownership or financial interest in the host. And when we get to the next amendment, we've actually required disclosure of all those business entities who would have a financial or ownership interest in that dwelling unit. So I think that, and that will go on the registration form to the county. So I think that that may help assist with that. I would ask for favorable support. I don't know, Ms. Lacey, if you wanted to add anything else.
I will after others' comments.
Yes. Mr. Pruski?
I'd like to hear the administration position, then I have a few questions.
Sure. The administration?
The administration has no objection to this. We'll be able to enforce however the property is held. I would just remind the maker of the amendment that there is a cost.
Mr. Pruski?
Thank you, Madam Chairwoman. As we went through this bill, I was trying to sort through, I've heard public testimony, other folks kind of explain the difference between the city of Annapolis, the county, and maybe this is a law office question for Ms. Kenny. If an HOA or a municipality such as the city of Annapolis wanted to further regulate, which my understanding they've already passed the bill, can go beyond what we currently have, am I correct? So when the Piney Orchard Community Association said you can't have chickens in your yard, but we allow chickens in Anne Arundel County, people can further take this law and restrict it based upon their own covenants, am I correct?
That's right. And the county would not enforce that, but an HOA could.
I understand. I just want to
Correct.
make sure that, for the record, we're passing this for Anne Arundel County, not for the city of Annapolis, not for a neighborhood, but we pass it at the 30,000-foot view for everyone. The second question that was brought up earlier, and this actually came up in my first term about the party houses, the evening rentals, and this may be separate legislation, but don't we have, and this may be something we have to research further, noise ordinance and parking ordinances that relate to those large party ordinances and things that would fall under that? Because I think, again, we want to separate. Normally what we think is a short-term rental is somebody's legitimately just staying overnight, not throwing the party of the century. So I just want to make sure, like, how can that be addressed? Because that was brought up by testimony, and this does come up frequently about people using homes. I know it's happened in Ms. Fiedler's district. It's been in the paper. And one in mine, I think they moved away, but that's okay. But I just, again, if you could answer that, because I think that's a very good question, so we understand what regulations we're passing here. And if you do have this, in some ways, isn't that separate? Because you could have a regular house where somebody's throwing, large parties. So if you could just address that overall.
Sure. For the record, Kelly Kenny, Supervising County Attorney. As far as the noise ordinance goes, that's correct. There is a noise ordinance that is enforced by the police department. So that would apply, whether it's your own house and you're being too loud, either unreasonably loud or exceeding the decibel levels that are set forth in the law, that would be a violation of the noise ordinance. So that would be enforced that way. Parking-wise, that would be dependent on the neighborhood and whether there's no parking signs or what the parking restrictions are in each individual neighborhood. But that would also be enforced the same no matter what the use at the house was.
Absolutely. And for those HOAs that are listening, as a former president, one of the things you can do is have parking on certain days, and you can work with the county to do that. So there is an option to kind of handle those types of things about when you park, how many cars, and other things. So that does work. But I wanted to make sure that was asked because some of the questions came up about what do we mean by short-term rental, and then also about who owns it, whatever else. And this is the last question, if you don't mind, Madam Chair, one. If I'm clear, Mr. Barron, you said that the county can collect this information, and it will be disclosed. So if somebody want to FOIA, Party Central LLC short-term rental, and there were 3 people involved, the county would be collecting that on a disclosure form, correct?
They really should come up with a better name.
I know. I'm just using that. That's the theme that came up.
Yeah, no, we would collect the information. I don't believe there would be any reason why we would have to protect it. So I believe it would be.
I just want to ask because I think about the HOAs and the people that are here.
Yeah.
That's their concern. How do I identify who owns this property? How do I get a hold of them if something's occurring? Because we want accountability here. I mean, we're certainly trying to regulate that business, but the purpose of knowing who they are is if you can get in contact with them, let's be honest.
And the State Department of Assessment and Taxation also has a website that you can look at any property in the state.
Thank you. Appreciate it.
Ms. Fiedler?
Thank you, Madam Chair. For the administration, you mentioned there's a cost associated with
any regulatory activity.
Right. In the bill, page 4, line 6, the fees of $400. My understanding, having some extensive knowledge on the background of this bill, is that fee is specifically to cover such costs.
Yes, that's the intent, I believe.
Okay, just wanted to clarify. Thank you.
Ms. Rodvian?
Thank you, Madam Chair. I actually have a question specifically about this amendment. This is I'll throw the question out there and ask for your help in answering it. So one of my constituents testified about the possibility of different types of ownership making it difficult to trace it back to individual human beings. And that was one of the original aims of the bill, is to limit this to individuals. And I'm envisioning, just by the language in the bill, you could actually have, a very large corporation that had multiple owners, and that would, presumably require the listing of, maybe, I don't know, you could imagine a dozen or even 100 owners, depending on the nature of the corporation. And how feasible is it to actually be able to trace back the ownership to the individuals? And what kind of burden do you think that would create in terms of enforcing the 2 per individual limit on short-term rentals?
I don't know if we can actually answer that question. It's a difficult one to answer. I would say that this amendment adds a layer of complexity that's not in the bill as drafted.
Do the others at the panel have any thoughts on this? That was a wonderful, helpful answer, Pete, but I'm curious to hear others.
In as many years as I've had to do this, go find corporations and who owns that corporation, it does take a concerted effort to do that. It's not just as easy as looking in a phone book, but you have to search in many, many different places to find out what entity is. And then that entity is usually covered by a resident agent. So your contact is with the resident agent at first, and then you have to go find out how many other people are on that list. That could be a very cumbersome and very complex issue to answer your question. I could have 6 tiers, whatever. The next company is 7 tiers, all represented by the same resident agent. I could have the wife and husband over here, and then I could have the daughters and the children on the other one as being part of that. So that's going to make it very complex to say you only get 2.
And would that, in your mind, would that create a possible avenue for property owners to have a way to get around? I mean, of course, you would go to the furthest ends possible to identify who those ultimate owners are, the individuals that have ownership. But it would appear to me that that would create a way for property owners to get around that 2-property limit.
Potentially, yes. However, you're in business, and business is supposed to be honest, and you're dealing with people who are coming into compliance. I don't know that you're going to have that issue with people who want to comply. There are always going to be people who don't want to comply and want to skirt everything. You're going to have issues with a small percentage of them.
All right, thank you. I appreciate that. Oh, I'm sorry. May I ask one additional question, please?
Yes.
Thank you. We mentioned the possibility of an HOA being able to set, some of its own limitations on short-term rentals. Would the type of ownership be something within the purview of an HOA? Would they be allowed, for example, to limit the type of ownership to individuals and not different business entities if we pass this? Is that something an HOA would be legally allowed to do?
Sounds like, yeah.
Kelly Kenny, Supervising County Attorney. I'm not sure on the answer to that question. I'm not sure whether an HOA would be limited or prohibited from doing that. I think it could be within the realm of possibility of something that they could limit if it was set forth in their HOA documents. But I'm not positive on that.
Thank you.
Ms. Hare?
Thank you, Madam Chairwoman. Ms. Kenny, I think this is for you, but I mean, an HOA and its restrictive covenants could even restrict, you can't have a short-term rental at all. Isn't that correct?
Right.
Yeah.
And that would probably be more likely than to restrict the ownership.
Okay, thank you.
Mm-hmm.
Oh, Ms. Schuett, did you have
I did. I
something to
just
add?
wanted to make one clarification. The $400 fee for a 2-year registration under this bill was set at a time when the amount relied upon what was in the bill at that time. So it may, or I don't know whether it would continue to cover the cost associated with looking into ownership. It may or it may not, but I'm just saying the fee was set prior to that concept.
Thank you. Oh, Ms. Fiedler.
Thank you, Madam Chair. One quick question also in relation to the $400 fee. Does that too apply to those homeowners that only wish to rent out for the 2 most utilized short-term rental events in our area? Would they have to pay that $400 fee, or could they pay it the first year and then when they have proof that they only do this once a year, then request exemptions from it? I'm not seeing protections there.
I don't think there's anything in the bill that would give them a waiver for the following years.
Okay, thank you.
Ms. Rodvian.
Thank you, Madam Chair. With respect to the fees, we had discussed that the fee was, as Ms. Schuett mentioned, intended to cover the actual costs. And just as the sponsor of this bill, I will state on the record that I would be happy to revisit the fee issue further down the road if we determine that this is exceeding the actual cost, or I suppose it's possible then it actually does not cover the full cost. So I would be very open to revisiting this part of the bill, if we determine that it's actually not the appropriate point on the scale to set this fee.
Mr. Volke.
Thank you, Madam Chair. Thank you, Councilwoman Rodvian. I think that's kind of where my next question was going, which is, can anyone give the justification for how the $400 was reached? What's sort of the thought process that's gone into that?
I would defer to the drafter of the bill and the sponsor.
Ms. Rodvian.
I will defer back to the offices that would be the ones administering the bill, because I believe that's where we came up with those original figures. So the different costs of, personnel to collect the registrations, to make sure, to verify the registrations, to collect the fees, to monitor the returns that are collected, any pieces that I might be missing. And just to clarify, it's $400 for 2 years, so it's $200 for 1 year.
Mr. Volke.
Oh, I think that answered my question.
Oh. Ms. Lacy.
Thank you, Madam Chair. I just speak to ask my colleagues to support this amendment number 10. Our discussion has veered a little bit off onto some other parts of the bill, but just to focus back on amendment number 10. Ms. Hare and I worked together on this amendment because we agree that it's unfair to try to limit the ownership to just individuals. And I think we can think, I suppose, as attorneys, we're thinking of all these different scenarios, but one really is something as simple as estate planning, and that somebody may have, 6 members of their family who get together, they form a limited liability partnership, or LLP. They pick someone to be the managing member or the managing partner of their LLP. That person runs the short-term residential rental, and the family shares the proceeds. And there's nothing legally wrong with that. And so my concern is both that it would be unfair, and that I'm not sure it would actually be legal for us to restrict ownership to just individuals. I think that's why this amendment reads very broad, but at the appropriate time, we'll be offering another amendment that also helps to ensure and serve as a check to keep compliance with the 2 rental limit. So with that, I ask that you support the amendment.
Ms. Rodvian.
Thank you, Madam Chair. I just thought of another question that I wanted clarification on. Because the bill, the 2 property limit actually begins with the property owner's own home. That's property number 1, and then a second property. How does that play in when you're talking about different business entities opening or owning? I guess, does a person own their own home in the name of an LLC? They can?
Sure.
Okay.
For the record, yes, they can.
Okay. No, thank you. I appreciate that.
Any further comments from the administration on this amendment? Madam Secretary, please call the roll on amendment number 10.
Ms. Hare?
Aye.
Ms. Lacy?
Aye.
Mr. Volke?
Aye.
Mr. Pruski?
Aye.
Ms. Fiedler?
Aye.
Ms. Rodvian?
Nay.
Ms. Pickard?
Nay.
5 in the affirmative, 2 in the negative. Amendment number 10 is adopted.
Madam Secretary, please read amendment number 11.
Amendment number 11, this amendment requires a registration form to include contact information for all persons with an ownership or financial interest in the host.
Is there a motion to adopt?
So moved.
A second?
Second.
This amendment is also introduced by Ms. Hare and Ms. Lacy. Hare?
Thank you, Madam Chairwoman. I think this just covers at least some of the concern about the burden of tracking down who owns what. Page 3 of the bill, line 44, currently requires in the application the name, mailing address, email address, and phone numbers of the host. This requires that and all persons with an ownership or financial interest in the host also be disclosed. So in terms of tracking down the ultimate people with an ownership, that hopefully the heavy lifting is going to be done on this initial form when the property is registered. So we're trying to take that concern away and take that administrative burden away from you all.
Ms. Lacey?
Thank you, Madam Chair. And literally, Ms. Hare and I were talking about kind of trying to diagram out what all these various possibilities were and really simplified it down to just have them disclose everything on the form, because our assumption is, or at least as we envision how this would work, is that the county would take the information from the form for all of these disclosed ownership interests and, you know, essentially put it into a database, a big spreadsheet. You can, and then search and mark on it who is on a registration form. So if somebody owns, they're on there once and then their LLC is on there another time, you're marking that off and tracking whether there's one or two or none of the registered rentals.
Would the administration like to respond?
For the record, Pete Barron, I would agree with the makers of the amendment. This should reduce the administrative burden of enforcement.
Ms. Rodvian?
Thank you, Madam Chair. I just wanted to say to my two colleagues that introduced this amendment, I appreciate your bringing this amendment in order to mitigate my biggest concern with your previous amendment. So while that one passed and I didn't support it, I'm happy to support this one, and I greatly appreciate that you included this in your package tonight. Thank you.
Any other questions or comments? Madam Secretary, please call the roll on amendment number 11.
Ms. Hare?
Aye.
Ms. Lacey?
Aye.
Mr. Volkey?
Aye.
Mr. Pruski?
Aye.
Ms. Fiedler?
Aye.
Ms. Rodvian?
Aye.
Ms. Pickard?
Aye.
7 in the affirmative, none in the negative. Amendment number 11 is adopted.
Madam Secretary, please read amendment number 12.
Amendment number 12. This amendment exempts dwellings used in connection with agritourism from the requirements of this title.
Is there a motion to adopt?
So moved.
Second.
Is there a second? Any discussion? This is Ms. Fiedler's amendment.
Yes, thank you, Madam Chair. If you look at the section of the bill that this is proposed to go into, it does not include a boat that is or could be used as a dwelling unit. I think boat houses and farmhouses are very unique, and based on the discussion that we have had around this bill, we're really focused on those high-density communities and the potential for them turning into hotel scenarios. I think the agritourism community is a little different in their acreage and their use than a regular residential property with a short-term rental.
Ms. Hare?
Thank you, Madam Chairwoman. I'm just going to say thank you to Councilwoman Fiedler. I think this is a great amendment, and I really appreciate it. I do think a lot of the concerns that we hear surrounding short-term rentals are things like noise and the number of times things turn over. If you think about sort of a farm stay and it's 100 acres or whatnot, your neighbors are probably much less concerned with noise. You know, if you're coming to sort of, I don't know, stay and work on the farm or enjoy nature for that time period, I think it's much less likely to pose a noise risk. So I'm happy to support this.
Mr. Pruski?
I'm ready to vote.
Oh. Ms. Hare? Ms. Lacey?
Thank you, Madam Chair. Mr. Pruski, quit doing that. You're confusing everybody.
I'm always ready to call the question, you know me.
So I think I'm not going to support this amendment, and I just want to explain why. Because as it's written, or a dwelling unit used in connection with agritourism is very broad. I overall support the idea, but I think what I'd like to see is a separate bill that addresses agritourism specifically and what the dwelling units in connection with it are. We have a history of treating agritourism separately, and so I think that would be appropriate to not insert it here, assume the broader law applies, go ahead and work on another bill, but make sure that, because as you said, the noise is different and there are other concerns that are different. So that's my thinking on this amendment.
Ms. Rodvian?
This was a question maybe for the Office of Law. With respect to 8819 that we just passed, the taxation revenue piece of this, how would these two interplay? This would not impact that legislation at all, correct?
Well, I was just looking at that and, not having the time to think about this beforehand. I think it would actually impact the taxation bill because the two definitions are really tied together. So if under 8919, the bill we're looking at now, if a short-term rental is the rental of a dwelling unit, now a dwelling unit doesn't include a unit in connection with agritourism, and then if you look at 8819, short-term rental means the rental of a short-term residential rental, so I think it all ties together. So I think there would more likely than not be a scenario where the agritourism rentals would not be subject to the tax if this definition was amended that way.
Thank you.
Ms. Fiedler?
Oh, sorry.
Oh, Mr. Volkey?
Thank you, Madam Chair. I guess my concern with this particular amendment, and I understand the intention of the sponsor, but I guess I'm not entirely clear on why we're already exempting out boats and saying that's one classification. Now we're doing agritourism, we're saying that's another classification. I'm not entirely clear why we're sort of creating all these subgroups instead of saying this is the rule. So I don't know if anybody can explain kind of the rationale for these different needs to carve out this piece and say this doesn't apply to them, this doesn't apply to them.
I don't think the administration has weighed in officially on this amendment.
Yeah, so the administration received this amendment maybe 20 minutes ago, so we are still looking at it. I think I would kind of echo Councilwoman Lacey's point. I think not opposed to the intent, but I think we are a little concerned about how this interplays and works into this bill and the previous bill. So at the moment, we're not prepared to support. We would have to oppose. But again, not because we're opposed to finding some carve out for agritourism on some of the regulatory burden, because I think the sponsor's point is well taken, but just not quite sure how this would fit in coming in at the 11th hour.
Ms. Rodvian?
Thank you, Madam Chair. To respond to Councilman Volkey's question about, sort of leaving pieces out, or why are we making little carve-outs? The big one that I recognize is the idea that we wouldn't apply these two bills to properties that weren't advertised on platforms, on internet platforms like Airbnb, mainly from a practical standpoint of enforcement. If we don't have a good way of tracking what's out there, we can very easily track everything that's in our county on Airbnb or VRBO and the major platforms. But if, there's things that are, I think one of the testimony folks that testified tonight mentioned, a church bulletin board that might say, hey, I have a room open for someone that needs a place to live. It's just a matter of practicality and enforcement to make the law match reality. With respect to boats, I remember we had a conversation about this, and I can't remember why. There was a good reason that we left boats out, but I'm sorry, I don't remember what that conversation centered around. Do you, Ms. Schuett?
It's centered around another council person's belief that boats should not be rented out on a short-term basis. And But a reason for that, I don't know.
It wasn't me. It wasn't me.
It was all of you. No.
Let's go to the video.
Okay. Want to keep the conversation focused on amendment number 12. We have any other comments?
Madam Chair.
Oh, yes.
I'm
Ms.
sorry.
Rodriguez.
Because I've spent a lot of time working on this, I have lots of thoughts on it, so I'll try and keep them brief. I just wanted to echo some of the other thoughts. I really do, I would be willing to consider this concept, but I think because of the possible interplay, I can't support it now, but please know that I'm open to supporting, looking at this concept down the road.
Thank you. Madam Secretary, please call the roll on amendment number 12.
Ms. Hare?
Aye.
Ms. Lacey?
Nay.
Mr. Volkey?
Nay.
Mr. Pruski?
Nay.
Ms. Fiedler?
Aye.
Ms. Rodvian?
Nay.
Ms. Pickard?
Nay.
2 in the affirmative, 5 in the negative. Amendment number 12 is defeated.
Madam Secretary, please read amendment number 13.
Amendment number 13. This amendment reduces the fee for registration of a short-term residential rental to $25.
Is there a motion to adopt?
So moved.
Second?
Second.
Is there any discussion? This is Mr. Volkey's amendment.
Thank you, Madam Chair. So in light of my question that I just asked as to the justification for how we came up with this $400 fee on a biannual basis that needs to be paid and the lack of ability to kind of give any substance to that, I am proposing that we use a relatively nominal figure of $25, which would be about $12.50 per year, which would be the registration fee. So that's it.
The administration like to weigh in on this amendment?
Well, the administration asked the council to reject this amendment. The administration would be happy to let IMP talk a little bit more. The $400 number was not picked out of nowhere. There is a cost to this. It is a lot more than $12.50 a year.
Mr. Pruski? Yep. Do you have any other comments? Madam Secretary, please, Mr. Africa?
Good evening, Greg Africa, the Director of Inspections and Permits. As Ms. Schuett indicated earlier, the $400 fee was established even before the discussions of any kind of amendments tonight. We had some interaction with the county auditor's office and what kind of assumptions to use. And we didn't really have any clear assumptions on the number of registrations we're going to experience. But the $400 comes from, it's not an arbitrary number. We're expecting up to 300 registrations that we're going to deal with. And if we're going to reduce it all the way down to $12.50, that's not even an hourly rate of what I hire my employees at. So, and what Ms. Rodvian said, she was willing to revisit this in the future if it's too much, too little. But I feel that the $400 fee is fair at this point in time, not knowing what we're going to expect in a number of applications, and the drilling into who owns this property other than the LLC down to what Bill Bryant said, down to the 5th degree or beyond the resident agent. I don't know what you're expecting off the department when we talk about registration and their self-certification. What we're talking about tonight is going beyond that. So that's going to be a cost to the department. Thank you.
Thank you. Ms. Hare?
Thank you, Madam Chairwoman. I just want to try and understand, because I believe Ms. McQuaid said earlier with respect to 8819, not necessarily 8919, but are we trying to absorb this as well without hiring any new personnel? Because then I'm really trying to understand what the fee is. Or are we trying to hire somebody else to administer this 8919?
We are probably, Bill Bryant, Inspections and Permits. With the amount of detailed research that we're going to have to drill into each individual application, we're looking at one person minimum plus partial times for the chief of the section and some other clerical help. So that's where we're coming from. to make sure that the host platform has the correct numbers, to actually look at that, that's going to take some drilling into to see, to make sure that we only have 2 people registered for a property, or 2 properties per person. That's going to take some research to do. So we're going to need at least one body to do that.
And how much do we anticipate paying that one body?
I believe with perks or with, I'm going to guess, so please don't hold me to it. You're looking at probably about 80 grand.
Okay, I'm just looking at if I do 80 grand and we anticipate about 300 application, that would be $267. So I'm just trying to figure out, is there a way to properly set this fee such that we can do it with some sort of rationale as opposed to just throwing a dart at a board?
Ms. Hare, you came up with 267. That's 267 a year.
Okay, but again, so maybe the fee needs to go up. Maybe it should be 500. I'm just trying to figure out that we have a rationale for the fee.
We're willing to, Mr. Bryant said it's around $80,000. I don't usually want to go against what my assistant director says, but that's on the high end. That's more like an inspector type of person. It's going to range between $60,000 and $80,000. I choose a $60,000 range to try to go in as low as I can. $60,000 is a fee with all the benefits and everything, so we're really looking at the position that's around $30,000, which would be $15 an hour.
Okay, and that 60,000, if I do that math, that actually does come out to $200 a year. Is it possible that's how we backed into the $400 number to begin with?
Yes.
Okay, thank you.
Mr. Volke.
I just want to thank Councilwoman Hare for doing the math that seemed to be eluding others.
Seeing no other questions from my colleagues, Madam Secretary, please call the roll on amendment number 13.
Ms. Hare?
Nay.
Ms. Lacy?
Nay.
Mr. Volke?
Aye.
Ms. Pruski? Mr. Pruski?
Nay.
Ms. Fiedler?
Nay.
Ms. Rodvian?
Nay.
Ms. Pickard?
Nay.
1 in the affirmative, 6 in the negative. Amendment number 13 is defeated.
Madam Secretary, please read amendment number 14.
Amendment number 14. This amendment exempts hosts who rent 2 times or less per year from payment of the registration fee.
Is there a motion to adopt?
So moved.
Is there a second?
Second.
Is there any discussion? Ms. Fiedler, this is your amendment.
Thank you, and I would like to thank Mr. Tootle for coming out and testifying this evening. There are a significant amount of families in our county, specifically in the 5th District, who use their home as a way to support a small family vacation by renting out during the 2 major events of the year, the boat show and midshipman graduation, or I'm sorry, the midshipman event. And they put a lot of money into getting their home ready and making it livable for a 1-week period of time. Maybe they do it twice a year. I don't think that it's reasonable to hold them to the fee for that reason, and I ask that my colleagues support this amendment.
Does the administration have a response?
Again, administration has just received the amendment, so we're looking at it now. Maybe I have a question maybe for the sponsor, and maybe it's for Office of Law, but we say it exempts a host who rents 2 times or less per calendar year. What's the term of that rent? Would it be, could I rent the minimum in the bill, which I think is 120 days? So could I rent twice and be 2/3 of the year? Sorry, I don't know. Again,
I mean, theoretically, yes. For the record, Kelly Kenny, Supervising County Attorney. I think that could be the case. I actually had the same question with the 2 times. Does that mean, what is the limit on the number of days with regard to that? Is that just 2 separate rental periods? Is that 2 days? Or like Mr. Barron said, could it be extended like that?
The intent was 2 times in a calendar year.
Right. No issue with the intent and understand the intent. I'm just, again, just reacting to language now.
Understood. And at the appropriate time, I may motion to hold the vote so that we could address this and present a revised amendment if necessary. Correct.
Maybe I can ask the sponsor, if folks are just annually renting their house out for 2 specific weeks, are they using the VRBO and Airbnb platforms? And does this bill already define short-term rental to be more than a 2-week period? I mean, if you are using a platform, how is the county supposed to know that you only rent your house twice a year? If you're registering with a platform and you're now going to be paying tax, how does the platform know, and how does the county know that you only do that twice a year? Therefore, you would be not subject to this bill. Chairing this meeting and understanding this debate is complicated, so Ms. Lacey, do you have?
Thank you, Madam Chair. I'm not sure that this concept of this exemption would make sense to me, even if we defined the 2 times as being, 24 hours non-contiguous or something like that. Mainly because the bill is directed at hosts who want to use hosting platforms. And so they're taking part in a global market that we as the county council are saying we're trying to regulate and also make sure that we collect the tax. So folks who intend to host for only 2 times or less per calendar year, and let's just assume those are significantly shorter than 120-day periods, but for the 2 big weeks, if they're still getting their guests from Airbnb or whatever other hosting platform that they want to use, I think, what they're doing, my understanding of what they're doing is they're making money by whatever they're doing. They're doing it because they can gain money, not because they would lose money. And they have to consider that when they want to treat their home similar to a business. That's part of, I think, what ties back into the larger debate about the right to use a hosting platform versus just using local forms of advertising that aren't regulated, or whether you have to register as register your Airbnb or not. Are you trying to just share rooms locally with people who need a room, or are you making money on your house? And the concern of the sponsor, as I understand it, is that we are trying to limit the duration and limit the types, the requirements of how you can host and what you have to do because of a perceived and, as experienced, real destruction of the feeling of community in particular neighborhoods. So I think it's appropriate for anybody then to have to pay the full fee rather than getting an exemption based on the number of times that they offer their property for rent.
Ms. Rodvian.
Thank you, Madam Chair. This is a question I would imagine, both for INP and Finance. Is there any reason to think that if a property owner were only using their property 2 times a year, that the costs for processing the registration, the tax paperwork, and anything would be less than otherwise? Would the cost to the implementing departments be any different?
The Bill Bryant inspections and permits, the cost is going to be the same per application. It's still going to be the same amount of work for that one that's twice a year, 4 times a year, the whole year. It's still going to be the same cost, the same investigations, the same jurisdiction on it. So it's all going to be the same.
Okay. And would that be, can I ask the same question of Finance as well? I would think maybe Finance might have a slightly different answer.
Karen McQuaid, Office of Finance. Compliance would be the only issue, trying to make sure that, they were only doing 2 returns a year or whatever, they were renting for. We would have less to process, of course. The initial fees would be the same as far as getting them set up, the cost to us, getting them set up and everything. But yeah, if they were only renting twice a year, we wouldn't have returns more than, maybe twice, maybe once, a month for the year.
Okay, thank you.
Sure.
I would just suggest this is another issue. I'd be happy to look, as we sort of see how this plays out over the next year or two, to revisit this and see if, we can do some, once we have real numbers and all of this is in play, actual hours that have been spent, actual, number of properties that have been registered, when we have some actual numbers that we could revisit this issue, because I think you do raise a good point with this amendment.
Mr. Volke.
Thank you, Madam Chair. Out of the 300 assumed registrants that the county expects to have when this passes, how many of them would be this sort of extremely short-term rental, if you will, these folks who are only renting maybe 1 or 2 times a year?
Would have no idea.
So then where does the 300 number come from?
The 300 number is a number that was published by a study that we've read for Anne Arundel County. They looked at how many short-term rentals there were across the county and in the city. They came up with a pretty good number of between 275 and 300.
Okay, what year was that study?
Specific. I believe last year.
Okay, and who did it?
I believe it was the Visitors Bureau. I believe they briefed the council
They did.
early on.
So with that, that's their expectation, and the county has no verification on that, but we don't know beyond that sort of over top number of 300, how many of those fall into the category of boat week, for the boat show, people who are here for the naval commissioning, things like that. So we don't know what that number would be.
We have no stats as far as that goes,
Okay.
yes.
But would that include those folks? Is that what the study showed? That includes it? Okay.
Yes. And that was February 19.
Seeing no other comments or questions from my colleagues, Madam Secretary, please call the roll on amendment number 14.
Ms. Hare?
Aye.
Ms. Lacy?
Nay.
Mr. Volke?
Aye.
Mr. Pruski?
Nay.
Ms. Fiedler?
Aye.
Ms. Rodvian?
Nay.
Ms. Pickard?
Nay.
3 in the affirmative, 4 in the negative. Amendment number 14 is defeated.
Madam Secretary, please call the roll on amendment number 15.
I will read amendment number 15 into the
sorry.
record.
I was predicting the outcome. I thought I was on a good roll here.
Amendment number 15, this amendment exempts hosts who rent 21 days or less per year from payment of the registration fee.
Can I have a motion to adopt?
So moved.
And a second?
Second.
Mr. Volke, this is your amendment.
Thank you, Madam Chair. This is the same as the last amendment, except instead of having the amorphous concept of 2 times per year, this sets a number of days. Thank you.
Does the administration have a response?
This, I guess, is better. The administration is still concerned about doing this on the fly, and one comment I think we would make is this doesn't erase the administrative burden, and also the logistical issue of keeping track of number of days rented. I think that would both be on the renter and on us. I mean, maybe I get a good offer and I'm keeping it up for another week because my house is so great. So again, support the intent that's trying to come here, but just have concerns about tinkering with this because there is a cost to the county to administer this, and providing this exemption would possibly cost the county a lot of money.
Ms. Fiedler?
I just would like to thank my colleague for bettering the language of my amendment.
Ms. Rodvian?
Thank you, Madam Chair. I actually have greater concerns with this amendment than I did with amendment number 14, because 21 days or less could imagine, that could be 10 weekends of a 2-night rental, plus, 1 single overnight. So that could be 11 separate rentals that each requires a filing or that, requires records. So I actually think with all due respect, we were better before. So I can't support this because I actually think this could be just as large of an administrative burden as, any Airbnb. This might actually be quite typical.
Mr. Volke.
Thanks, Madam Chair. I would be happy to add to an amendment to say 21 days or less, not more than 2 times a year, sort of a mashup of the two, if that's something that my colleagues would think would be better.
I'd like to remind my colleagues that this bill was first introduced on November 18th, and we've been discussing this bill, and the influx of amendments this evening are extremely frustrating, and they don't give anybody the amount of time to really digest what we're voting on. This bill comes up to a vote next week, or next meeting, and if there seems to be problems with the bill, that passes. If it does, there's a chance to amend this public policy later. Personal privilege there as the chair. Any response from can we move on with this amendment? Madam Secretary, please call the roll on amendment number 15.
Ms. Hare.
Aye.
Ms. Lacy.
Nay.
Mr. Volke.
Aye.
Mr. Pruski.
Nay.
Ms. Fiedler.
Aye.
Ms. Rodvian.
Nay, and I would just like to reiterate my offer to revisit the costs, once we have actual numbers to address the concerns of my colleagues that have been raised tonight.
Ms. Pickard.
Nay.
3 in the affirmative, 4 in the negative. Amendment number 15 is defeated.
Thank you. Seeing no other amendments on bill number 8919, 8919 will, as amended, will be heard on February 18th, 2020. Breathe. Madam Secretary, please read the title of bill number 9419 as amended.
Bill number 9419, an ordinance concerning boards, commissions, and similar bodies and public ethics, Human Relations Commission.
This is an administration bill and sponsored by Ms. Lacy. The administration like to...
Sure, be happy to. Joining me at the table is Ms. Schultz from the County Exec's Office and Ms. Kenny from Office of Law. Bill 9419 has been discussed a couple of times now. I think it's prescient on the first council meeting in Black History Month for us to be talking about this. The county took a big step in codifying the Human Relations Commission back last fall. Like anything, we've been working hard to get it right. This bill added a couple of things. There were some changes. Those changes were changed in an amendment. And we think this is a good, solid bill. We ask that you pass it tonight. With that, we're happy to answer any questions.
Have any questions from my colleagues? Seeing none, we'll now open the public hearing. Remarks will be limited to 2 minutes. I do not have anyone signed up to speak on this bill. Is there anyone in the audience that wishes to speak on Bill 9419? Seeing no movement in the audience, the public hearing on Bill number 9419 as amended is now closed. Madam Secretary, please read the title of Bill number 9419 as amended.
Bill number 9419, an ordinance concerning boards, commissions, and similar bodies and public ethics, Human Relations Commission.
Is there any further discussion? Madam Secretary, please call the roll on Bill number 9419 as amended.
Ms. Hare?
Aye.
Ms. Lacy?
Aye.
Mr. Volke?
Aye.
Mr. Pruski?
Aye.
Ms. Fiedler?
Aye.
Ms. Rodvian?
Aye.
Ms. Pickard?
Aye.
7 in the affirmative, none in the negative. Bill number 9419 is passed.
Madam Secretary, please read the title of Bill number 9519 as amended.
Bill number 9519, an ordinance concerning public works utilities subsidies for wastewater extension project costs.
Ms. Hare, this is your bill. Do you want to speak to that?
Sure. Thank you, Madam Chairwoman. We've talked about this bill a bunch of times, so I will leave it, except for the fact that I believe everyone received a chart today that I believe was compiled by DPW that just shows sort of the cost per pound of nitrogen removed and sort of the efficiency that you get from these types of projects and the leveraging that we can get from private dollars doing it this way. Other than that, and if there's any other questions about what we've previously touched on, I'm happy to refresh anyone's memory, but that's all I've got for tonight.
The administration care to weigh in?
Happy to. Joining me at the table is Team Septic from the County Exec's Office, Mr. Johnson, from DPW, Mr. Phipps and Mr. Heiner, and from Office of Law, Ms. Kenny. Yes, this bill has been talked about at length. This is a good bill. It's going to help remove pollution from the bay. It's going to help communities with failing septic. I want to be clear that we are able to do this and make this work because of the tough choices this council made when we decided to roll back some of the irresponsible cuts to the connection charges. So our funds are fiscally solvent, and we are able to do that because of the tough choices that a number of you made back last budget. To be clear, you will, as the final fiscal authority for the county, have to take a look at each of these moving forward. So this is not a we get to run away and remove all the nitrogen from the bay, as much as Mr. Johnson would like us to. Well, I guess there's some that should be in there. But this is a chance for us to tackle in a systematic way that map that you all have in your packet of the communities across the county where septic is failing. So we hope you will support this bill.
Mr. Volke?
Thank you, Madam Chair. Mr. Phipps, thank you for compiling that document which was sent around. I appreciate that. I think it was in response to some questions that we had last time, and it was very helpful to see the impact of different things that you can do to try to reduce the nitrogen and other pollutants into the bay. One question I did have for you, what's the balance of your wastewater fund currently?
When you say the fund balance for the utility fund in total?
Yeah.
So that's water and sewer?
Yeah.
I don't have it immediately available, but it's around 200 million.
Okay, so you're sitting with 200 million effectively in the bank on this. And that's what you're going to be tapping into, plus some of these funds that are paying by the homeowners to get the subsidy to make this all work.
Right.
And you don't see any issue at any point running this out literally 60 years with your fund running out of money the way that this is structured?
No, we don't.
Okay, good. Thank you.
Ms. Hare?
Thank you, Madam Chairwoman. And just to respond on that, this is something, I mean, each one of these individual projects would have to come through DPW's budget that goes to the county executive, and the county executive would have to put it in his or her proposed budget to the county council, and it would be a line item in our CIP, our budget book, and the council would have the opportunity to say, this year, we don't feel comfortable with that dollar amount, let's strike it, or, you know what, we feel okay with it this year, let's not. So there's a lot of checks and balances all along the way for this. I'm just going to give a thank you to the admin support for this, for all the work that everybody has done. And you said it much better even than I could in terms of the systematic way we're going to try and attack this. So thank you.
We'll now open the public hearing on Bill 9519 as amended. I have no one signed up, so don't move, admin. Is there anyone in the audience that would like to speak on Bill number 9519 as amended? Seeing no movement, the public hearing is now closed. Madam Secretary, please read the title of Bill number 9519 as amended.
Bill number 9519, an ordinance concerning public works, utilities, subsidies for wastewater extension project costs.
Any further discussion? Madam Secretary, please call the roll on Bill number 9519 as amended.
Ms. Hare?
Aye.
Ms. Lacey?
Aye.
Mr. Volke?
Aye.
Mr. Pruski?
Aye.
Ms. Fiedler?
Aye.
Ms. Radvian?
Aye.
Ms. Pickard?
Aye.
7 in the affirmative, none in the negative. Bill number 9519 is passed.
Madam Secretary, please read the title of Bill number 9719 as amended.
Bill number 9719, an ordinance concerning zoning, housing for the elderly of moderate means.
This is a bill sponsored by myself, Ms. Lacey, Ms. Rodvian, and Mr. Pruski. We have talked at length about it. It has been amended. I urge my colleagues to support this bill as we work in this county to address our issues with affordable housing and some of our most vulnerable populations with our elderly of moderate means. This bill addresses some issues as far as timing of getting these projects up and running. Do I have any comments? Well, I'm going to let the administration respond.
Sure. Thank you. Joining me at the table is Ms. Rhodes from OPZ, Ms. Koch from ACDS, and Ms. Kenny from Office of Law. We have discussed Bill 9719 at length. I could reiterate some of the points Ms. Koch especially made at the last meeting about the need in this county. But if you'd like, just replay that testimony. The thing I do want to thank the sponsors and the entire council for taking some of the tightening amendments, particularly the lead sponsor. We worked closely to craft some tightening amendments to make sure that this bill addresses is narrowed to address the need that it purports to. So I think this is a good bill, and we support the bill.
Thank you, Mr. Pruski. Mr. Volke, excuse me.
Thank you, Madam Chair. I did have a question. I see on page 2 of the bill, line 31, are we keeping the prohibition on the units being occupied by resident minor children? Is that still in the bill? On page 2, around line 31. I feel like when I looked at the amended bill, I think that was in the original version of the bill, and then that might have been taken out by amendment number 2. I just wanted to clarify that I understood that correctly. This is the original version. This is the amendment.
Yeah, that language was removed and replaced with,
Madam Chair?
yes, Ms. Koch.
It was removed, and it requires that all individuals be 62 years of age or older, and this was a clarification to ensure that the new law adhered to the fair housing laws.
Okay, and so does that, I guess my question would be, is there still a prohibition on minor children being allowed to live there because of the new language that says that everyone there has to be 62 or older?
That's right, unless you have a minor who's over 62.
Sorry, I didn't hear you.
Yes, over 60, but I'll have to be over
Okay,
60.
so we agree
I'll
that
have to
that,
be 62.
that covers that,
Yep.
okay. And then the other question that I had was about PFAs, priority funding areas. I'd heard from some folks with GAN, the Growth Action Network, who are concerned that the PFAs, the requirement that these be located in PFAs, that many of the PFAs are already built out. So I wasn't sure if the admin could comment on whether there would be any openness to potentially removing the requirement that these be located in PFAs.
Well, I would defer to the sponsors
Okay,
of the
sorry.
bill, but the PFAs are, I believe, and I turn to the experts at the table, set and can be updated.
In the GDP, right?
Yeah.
Well, actually,
Well,
they
no.
can be updated as certain things are happening.
Okay.
Most of these require funding from the state and from the county, and in order to get that funding, you have to be in a priority funding area. And there have been times over my tenure where we have amended the PFA. There's a process that planning and zoning goes through with the state.
Okay.
And they can do it on a parcel.
Gotcha. Thank you.
Well, I would add 99.9% of these housing communities are funded through the state tax credit, the 4% and 9% tax credits, and their requirements are extensive. They go well beyond the designation of a PFA. So as we go through our GDP, that PFA boundary will probably shift and change. I don't know how we would further classify where we would allow it when it's already contingent on the state funding formula. Ms. Hare.
Thank you, Madam Chairwoman. I just want to go back for a second to Councilman Volke's question, because on page 2 in line 41, I don't see the word all. It says requires the units to be occupied by individuals who are 62 years of age or older, but maybe, Ms. Kenny, this is a question for you. I certainly envision a situation where you could have two 65-year-olds and a 14-year-old, and it would meet that definition. Am I misunderstanding?
Kelly Kenny, Supervising County Attorney. I think it could be open to that interpretation. I believe the intent is that all the occupants have to be 62 years of age or older. But it just does say requires the units to be occupied by individuals who are 62 years of age or older. You could interpret that to mean that all the individuals have to be that age.
But it is possible that it might be open to, I mean, because we are deleting, if you look, I suppose, at the legislative history, we're deleting the prohibition against any minor, and then we're putting language that does not use the word all. I think that we maybe fall into the possibility of being unclear here, and maybe we need to clarify that.
Well, it looks like the prior language, you only had to have at least one individual who was 62 years of age or older. And so then the prohibition was clear for the minor children. Now it requires that they be occupied by individuals who are 62 years of age or older. So it actually does appear that all the individuals have to be 62 years or older.
Okay. All right. My second question, we haven't talked so much about density bonuses in this particular bill. We talked about them in the prior bill in September timeframe of 2019 with the workforce housing, and I know that there was sort of a lot of discussion back and forth about whether a density bonus is appropriate in an R5 district, and here the density bonus is going down to R2. Does the administration have any comment on that? I recognize this is not an admin bill, but I am curious if you have any comment specifically on the density bonus given to R2 and R5.
If I can, and maybe
I'll be happy to
Well, I
weigh
do want
in.
to say one thing. I believe the previous zoning requirements would have the housing in R2 and R5 at special exception had a more generous density bonus than is provided in this bill.
So this bill essentially takes the same provisions in our code from special exception to conditional, just taking out an administrative step, which is time-consuming for folks trying to stand up affordable housing of this kind. This doesn't change. Actually, it does, as Mr. Barron indicated. It actually does put what I'm calling super conditions on the R2 and R5 that don't currently exist in the code, meaning that they can, so it's actually harder to build a larger community in R2 and R5 than it is currently in the code, although under special exception.
Okay.
This is not expanding any code or any density increases. It's actually dwindling down the number of units that could go in R2 and R5.
Correct. Lori Rhodes, Planning and Zoning. The current code says maximum density shall be 22 units per acre, not to exceed 120 total dwelling units. That's what it says currently by special exception. So this would reduce the density in the medium density districts from 22 to 60 in R2 or 120 units in R5.
Okay, thank you.
We'll now open the public hearing. Remarks will be limited to 2 minutes. I do not have anyone signed up to testify on this bill at this time. Is there anyone in the audience willing to, I see some movement.
Patrick, would you like to take the photo? Sure.
Good evening, Madam Chair, members of the council, ladies of the staff. My name is Patrick Enright, and from Gambles, Maryland. I wasn't intending to speak at all on anything tonight, but the issue of younger person under 62 living in one of these units, it eliminates caregivers who would be younger than 62, who would be resident or not perhaps for the whole time of a person's life, but at 62, perhaps a person living there turn 79, and all of a sudden they need official caregiver as a resident. So you may want to think about that as an issue, unintended consequence of eliminating younger caregivers living there. That's it.
Thank you.
Sure.
The public hearing on Bill number 9719 as amended is now closed. Madam Secretary, please read the title of Bill number 9719 as amended.
Bill number 9719, an ordinance concerning zoning housing for the elderly of moderate means.
Is there any further discussion? Ms. Lacey?
Thank you, Madam Chair. I just wanted to offer a response to Mr. Enright's question and to others who are concerned about this age 62. I asked, excuse me, our legislative counsel for advice on this because I agree that persons younger than 62 should be able to live in this housing, especially to support the 62-year-old or older person. And she pointed me to some publications from HUD that explained what housing, how they define housing for the elderly of moderate means, and this age restriction that, as I understood it from Ms. Koch, who advocated to make sure that we included it, is to help make sure that our law is congruent with that law and the understanding of that law, which still didn't satisfy me until I found a line that said that caregivers were accepted from the age restriction if they were living in with the owner. So I don't like it, but seemed good enough to move forward.
Mr. Volke.
Thank you, Madam Chair. I'm going to start with this. I'm going to support this bill, but I do have some concerns about it. I hope that we're not opening up issues that we can foresee but aren't dealing with. You know, one of my concerns is the special exception to conditional, which takes out a public hearing. I like having people getting the chance to weigh in. So for me, I think that's disappointing that we're moving in that direction, but I also agree that there are some very strong conditions that have to be met in order to allow this to happen. I also like that we are reducing the maximum density in R2 down to 60 units, though we are increasing the amount of gross area coverage. So I do have some concerns with this. I hope that this isn't something we have to come back and revisit, but I also agree with many of my colleagues that we have a serious crisis when it comes to housing, particularly for folks who are elderly. So I will be supporting this bill because I think it's the right thing.
Ms. Hare.
Thank you, Madam Chairwoman. I have a number of the same comments as Councilman Volke, except I'm going to fall just shy of the other side of the vote. In this particular instance, given the concerns that we've heard about the overdevelopment and things like that, I just, for right now, I think special exception is the right place to be. That I appreciate the changes to the dwelling units in R2, and I appreciate the other restrictions and whatnot that have been placed on it, but particularly for sort of those lower density residential areas, I think the special exception is the right place for now.
Ms. Fiedler.
Thank you, Madam Chair. I echo the sentiments of my colleagues. I was not present for the amendments, but I do appreciate that my colleagues put more conditions on this type of project. Where I struggle is I've looked over the history of projects elderly of moderate means in our county, specifically in my district. There have been a few, and none of them have been thrown off of their timeline or prohibited from moving forward because of going through the special exception process. So I just don't feel that at this time this is a necessary bill to move forward, so I will not be supporting it this evening.
Madam Secretary, please call the roll on Bill number 9719 as amended.
Ms. Hare?
Nay.
Ms. Lacey?
Aye.
Mr. Volke?
Aye.
Mr. Pruski?
Aye.
Ms. Fiedler?
Nay.
Ms. Rodvian?
Aye.
Ms. Pickard?
Aye.
5 in the affirmative, 2 in the negative. Bill number 9719 is passed.
Madam Secretary, please read the title of Bill number 120.
Bill number 120, an ordinance concerning public safety school bus monitoring cameras.
Thank you. This bill was brought forward by the administration. Myself, Ms. Rodvian, and Mr. Pruski are all co-sponsors. Mr. Barron, would you like to take the lead on this?
Be happy to. I would be happy to. Pete Barron for the administration. Joining me at the table is Mr. Shagnovich and Mr. Mosier from the schools, Major Passman from the police, and Ms. Kelly Kenny from Office of Law. We discussed this at the work session. This bill will enable the county to put school bus monitoring cameras on our buses. I believe one of the things I said at the work session, we've all seen it happen, right? Somebody is impatient while a school bus is stopped and goes past it. I actually saw a near-miss video on the internet just the other day somebody sent me. It's terrifying, and this bill won't stop people from being reckless and irresponsible, but it will allow us to find them and deter them and hopefully lessen this. So we hope you will support this bill. I think it's a reasonable bill. We will still have to implement it. The folks at the schools, I'm sure, can enlighten you on any questions that you may have about that process. But this is there's a reason this is the first bill of the year from the administration. So with that, we hope you will move this bill forward and help make our kids a little bit safer on their way to school.
Mr. Pruski?
Thank you, Madam Chairwoman. I'm a co-sponsor of this, and I want to thank the administration for coming forward. I think the important piece here is, if you look at this bill, the first thing is public safety. And some of our most vulnerable citizens are obviously our young children. And there has been several instances, not only in the paper, but from parents in my district and also from the police, of instances where somebody could have seriously been injured or already has been injured. So to me, this is a use of technology to its best. I do like the fact that there'll be an RFP, there'll be competitive bidding. As a school system, I've discussed that with them, so this is not something that we're going with one company. And I think this is the way to go. And I still have some work to do, but I believe that speed cameras also in this county need to move forward. We need to help our police use technology to make sure that, public safety is priority number one. So thank you.
Ms. Lacey.
Thank you, Madam Chair. I see that school bus monitoring cameras are defined in the State Code Transportation Article, Section 21-706.1, as cameras placed on school buses that are designed to capture images of drivers of motor vehicles violating the prior section, which makes it a crime to go around a school bus with the arm out. Is there already a limitation or an implication or I'm having trouble envisioning whether the cameras that we're talking about are only on the arm or are they on other parts of the bus? And is that, or maybe that's covered in the state code that I didn't read, so give me an F today, but.
Sure. If I may, Alex Shackno, Chief Operating Officer. So the cameras are permanently affixed on the exterior of the bus. With respect to the legislation that's before you, they are not on at all times, the exterior cameras. So there is a micro switch that once the stop arm is deployed and the emergency signalization system on the bus, which is the fixed beacons and the amber and then ultimately red flashing lights, those are codified within both state law and federal Transportation Act laws, what those have to be, what they need to look like, how they need to be deployed. When they are deployed in the manner that comports with state and federal law, that is when the imagery begins to take place. And I'll let the major speak past that point, but it is from that point on that the camera could be capturing evidence of an infraction. So they are not on the full time that the bus is going through the communities. It is only when they are in their stopped position with the stop arm fully deployed, with their legally required signalization systems fully deployed. That is the window that we will be capturing the footage that would then comport with this legislation.
And is there a prescribed number of cameras per bus and the locations on the bus where they're to be placed?
No, ma'am. So that's proprietary. There's a number of vendors in this space that would be part of the RFP process. The footage has to be of a specific and sufficient quality and quantity to allow the law enforcement professionals to adjudicate the infraction. So there is certainly a quality aspect to it to allow our uniformed officers to do their jobs.
Okay. I have no idea why it would be proprietary, the number of cameras and where they are on a bus.
You certainly need a certain number of cameras to get pictures from the different angles, but if one piece of technology can have 2 cameras that can do it, and another vendor takes 4 cameras to do it to the required resolution, et cetera, we don't want to preclude vendor B versus vendor A. So we sort of want to let market forces, play that out. But we've committed to the administration that we actually want and prefer and are asking the county to be part of our RFP, RFQ process to ensure that the vendor that we select comports and fulfills the requirement that county law enforcement would need.
Okay, because in that once that footage is taken or is available, you're going to have a retention period. You're going to have other regulations that deal with what that footage can be used for, and perhaps even private parties. Maybe there's an accident with a school bus and they need that footage for their for their insurance company or something. I mean, I think my only concern with this, I agree with it from a public safety standpoint, but I'm concerned about the potential for setting a precedent of how many more cameras are going on the bus and where do they go. At what point are we monitoring student behavior inside the bus? Because it could be relevant. I'm concerned about where that ends. And I think by working together with the county, that includes having some review of what the RFP looks like so that we ensure that we're not crossing over a line, especially that we don't intend to cross, then I would be supportive.
Mr. Volke.
Thank you, Madam Chair. Do we already record inside the bus?
We do.
That's what I thought. Okay. Not everywhere. Okay. The question I have is about the apparatus that you're buying. The equipment is the word I'm looking for.
Yes.
Who's going to own it? Is it the bus company or is it the county?
No, sir. Actually, it's
the company that
it's a
puts it on?
third-party vendor. So there's no upfront cash outlay on the part of the public.
Fantastic.
The company owns the equipment. They install it. They calibrate it. They monitor it. They provide feeds. They will also provide expert witness testimony should a matter go to trial and the veracity of the equipment or the calibration needs to be questioned, et cetera. That's another service that they provide.
Okay. So the fiscal note indicates that there's no fiscal impact to the county, and it sounds like from an outlay cost, that's correct, that they're going to be putting this on buses, they're going to own the equipment. How are they going to be paid? What's the typical arrangement that you see with these vendors?
So that's also going to be part of the solicitation. So again, in collaboration with the county, we're going to come up with a scoring rubric.
Okay.
It's going to provide weights for different factors. One of the factors I would suspect, it's not yet been developed, but as I've seen them transpire across neighboring jurisdictions here within Maryland, one of the scoring points is what is the percentage that company retains for the cost of their services and naturally their profit overhead, et cetera. So that'll be part of the scoring evaluative process.
Okay, so if I'm understanding, effectively there would be a fine amount, and for every fine that's collected, there's a certain percentage that they would potentially retain as their fee for having put this equipment on and monitoring it and providing the testimony and all that.
Yes, sir. And state law prescribes what the maximum fine level is. The county certainly could elect to do a number lower than that, but the state law prescribes what the maximum fine is utilizing this technology. And it's important to note that this is a civil citation, so the fine amount in this case is significantly lower, and the penalties are significantly lower than an actual violation that's witnessed by one of our sworn officers. That is a different violation to a different standard.
Why is that? If Major Passman knows, seems like the same violation.
Well, no, all camera type incidents, you don't know who's driving the car, so the violation goes to the registration and not to a driver. So
Right.
it's not a moving violation where points are assessed to a particular person that would be getting a ticket.
But is the fine lower than what you would get if a police officer saw you doing it?
For this offense, yes.
Really?
This offense is expensive.
What's the difference between the two, if you know? This is my curiosity more than changing how I'm going to vote.
Yeah.
I believe, top of my memory, I think it's 250 versus 600. Wow. I believe. But both values are prescribed in state law.
Okay.
So, Kelly Kenny, Supervising County Attorney. The civil penalty under the subsection for the cameras, I believe, is $500. Maybe is that right? I'm sorry, that's for the police officer witness offense is $500.
Up to 500.
Yeah, it's 250.
Okay, and so Mr. Shaknovich was correct, 250.
Okay. He usually is.
I should have been.
It's 50-50 tonight, sir.
I just have one final comment I'll say. Typically, I think we do what are sometimes called sin taxes, where we say to people, if you're going to do such and such a thing, whether it's alcohol or tobacco or gambling, we put a tax on top of that, typically because we say if you're going to engage in that activity, we're going to make money off of it. And I think this is exactly the type of thing that we should be looking at to say, we want to deter this. Typically when we tax something or we find something, we get less of it. And obviously that's what we're doing here, is we're trying to fix a public safety problem, and we are trying to say we want less of something, which is people running around school buses. So I think from a philosophical standpoint, this is exactly what we should be doing.
So I have to give a shout out to Mr. Dixon's fourth grade class at Marley Elementary School, who I met with Friday morning, and we analyzed this bill quite carefully. They did a I see, I think, I wonder Socratic method exercise. And many of the students have witnessed this issue happening with their school bus. I was there to talk with them about walkability and school safety, and they had came to some of the same conclusions as folks on the dais here. So I'm pleased that I'm hoping we're going to get a unanimous vote on this bill for both the fourth graders at Marley Elementary School and for all the students in this county. Do we have any further comments on this bill? Oh, Ms. Fiedler.
Thank you, Madam Chair. I want to thank the sponsors of this legislation. There was a very publicized incident in my district in Severna Park where there was an actual accident, and the student, from my understanding, still has not returned to school. For every one of those, there's many more near misses, and as a parent of 3 young children in our public school system, I think we should do the utmost to protect our young children who are getting off of buses and deserve a safe trip to their home. So I will be supporting this bill.
We will now open the public hearing on Bill number 120. The remarks will be limited to 2 minutes. We do have one person signed up, Ms. Michelle Corkadell. Welcome.
For the record, Michelle Corkadell, President, Anne Arundel County Board of Education. Madam Chair Pickard, Madam Vice Chair Lacey, and distinguished council members, thank you for your continued dedication to our county and, more importantly, our students. I just wanted to take a minute to express the board's gratitude and support for the county council bill that will allow AECPS to contract for the installation of school bus monitoring cameras and authorize local law enforcement to issue citations to drivers who violate the law and endanger the lives of AECPS students. I also want to recognize the efforts of Dr. Arlotto and his staff, who have prioritized this issue and have been in talks with the county government for over a year. Dr. Arlotto's leadership on school bus monitoring cameras has resulted in county government introducing this very important bill. I'd also like to note that an added benefit of having the school bus monitoring cameras is the GPS capability. Having this GPS could allow AECPS to possibly develop an app to allow parents and guardians to eventually track the location and arrival times of their child's assigned bus. This team effort between the superintendent, his staff, and the county executive, as well as the county council, has resulted in common sense legislation that will help keep our AACPS students safer. I thank you for your consideration, time, and great efforts on this important issue for our county, but most importantly, our students. Thank you.
Thank you, Ms. Corcadell. Is there anyone else who did not sign up who wishes to speak? The public, seeing no movement in the audience, the public hearing on Bill number 120 is now closed. Madam Secretary, please read the title of Bill number 120.
Bill number 120, an ordinance concerning public safety school bus monitoring cameras.
Is there any further discussion? Madam Secretary, please call the roll on Bill number 120.
Ms. Hare?
Aye.
Ms. Lacy?
Aye.
Mr. Volke?
Aye.
Mr. Pruski?
Aye.
Ms. Fiedler?
Aye.
Ms. Rodvian?
Aye.
Ms. Pickard?
Aye.
7 in the affirmative, none in the negative. Bill number 120 is passed.
Madam Secretary, please read the title of Bill number 220.
Bill number 220, an ordinance concerning public works, roads and rights of way, obstructions, abandonment of facilities.
This bill was introduced by the administration and is co-sponsored by Mr. Volke. Would the administration like to kick it off?
I would be happy to. Pete Barron for the administration. Joining me from DPW is Mr. Phipps and Mr. Beckier, and from Law, Ms. Kenny. This bill comes out of some very productive discussions with our agency, Councilman Volke, to bring forth an ability for the county to address a problem we face when owners fail to relocate or remove obstructions and abandoned infrastructure in county roads and right-of-ways. Anne Arundel County has had several road projects, including, so I'm going to name a few roads. It's not a fully inclusive list, but we tried to gather places where this has happened across the county. So Pasadena Road, Cape St. Clair Road, Sunrise Beach Road, Chesapeake Center Drive, Forest Drive, Maryland 214 and 268. Those have suffered inexcusable delays and disruption due to buried utility conflicts and or unresponsiveness from the utility companies to remedy the conflicts. To be clear, this bill is not intended to be a gotcha bill or a punitive bill on the utility companies. This is a tool for the county to use to gain compliance, to ensure that we're not wasting taxpayer money while we have a road project that is stalled out because of a particular utility that is in the way. It's always the goal of this administration, previous administrations, and I assume future administrations, to work with the utilities to make sure that they're in communication throughout the entire project. However, sometimes we need a tool to make sure that we can get action because frankly, there might not be any profit in moving a telephone pole that's in the middle of a road, which is a picture Mr. Phipps sent us earlier. So what this bill seeks relief in county code is to ensure higher level of accountability, accuracy, and responsiveness, on the part of utility companies. So this bill adds a 45-day deadline to remove infrastructure that obstructs a county road, easement, or right-of-way. If the obstruction is not removed within 45 days of notice received from the county may suspend active permits permits or issuance of a permit until the obstruction is shifted, adjusted, accommodated, or removed. If the obstruction is still not removed, this bill authorizes the county to shift, adjust, accommodate, or remove the obstruction. The bill also requires utilities to remove abandoned above-ground infrastructure in the right-of-way. Underground infrastructure may remain in place with a permanent record of its existence at such time. Failure to comply is a Class B civil offense, with each day constituting a separate violation. I would like to thank Councilman Volke, the folks sitting at the table with me. A number of hours went in to craft this bill. I understand we caught a couple of issues at the work session, and there will be a couple of amendments coming forward, but the administration looks forward to a productive discussion on this bill.
Are there any questions from my colleague? Oh, Mr. Pruski?
Thank you, Madam Chairwoman. Mr. Barron, you and I had a conversation, and again, I just wanted to understand, I'm not an attorney, but I play one on TV. When we say 45 days and 60 days, is that business days? And the reason why I say that is because I know that over holidays sometimes contractors are closed, other things, and some of this is open for interpretation on how the county's going to feel. And also, you mentioned the word may as opposed to shall. And being in this business for a while, I want to be very clear how we're going to implement this in terms of those two questions.
So I'll take the latter question first, then I'm going to turn it over to a better attorney than I. There is an amendment coming forward to address the may-shall issue that the administration will be supporting.
Sure. Cali County Supervising County Attorney, I can answer the calculation of days. That's set forth in the general provisions of the code. So if it's more than, I believe it's either 7 or 10 days, then it's just calendar days. So you just count the number of days, so it's not business days.
Okay. I just want to be clear in understanding what you meant by that. Thank you.
Mr. Volke?
Thank you, Madam Chair. I also want to thank the administration for working with me on this bill. We were sort of moving on simultaneous tracks. There was an issue in my district that this arose and got onto my radar, and then when I was reaching out to the departments for comment, it became clear that the administration was looking at this too, so we were able to work together on it. I think it was really productive. I appreciate everybody's time and effort that's gone into this, particularly Department of Public Works for meeting with me to sort of walk through particularly the Pasadena Road project in my district and some of the hangups and delays that happen with that. Just for the benefit of my colleagues, I'm going to lay this out. There was a very good timeline that had been developed by DPW as to how they wanted to do this road project in my district. Ultimately, the road turned into what can only be described as a debacle. 2 years, multiple delays, digging test pits to figure out what utilities were underground, marking lines, then coming in, starting to dig, hitting lines, taking power or other utilities out, having to come in and fix them, moving the project down the street, coming back. In the end, it's literally unexcusable. There is no reason that the taxpayers should be on the hook for some of these things. And I can't blame all the utilities the same, because certain ones may have been more responsible than others, and I think that's the case on all of these. The issue with this bill, and what this is really aiming to do, is sort of give the county a last resort, if you will. The county, as I understand it, is going to continue to try to work and be a very good partner with the utilities using our right-of-ways. This is not intended, as Mr. Barron said, to be a gotcha bill or a kick you out or a we don't like you type bill to these utility companies. But what it is intended to do is say, when we get into a situation where we have a public works project and your private use of our right-of-way is impeding our ability to continue spending tax dollars wisely, at that moment, we need to do something to make sure that we're not wasting the people's money who give it to us that we're supposed to spend. And that's the key with this bill. This is not intended to penalize anybody or punish them. It's just intended to be sort of a what's going on type bill. When we get to the end of our rope where the county has tried everything they can to get the utilities to work with us and it's not working, the county needs to have something that they can fall back on. So that's the intention of this. I have been able to get some feedback from some of the utility companies. I know that there are concerns with certain parts of this bill, but what I would say is I think overall it's the intent of this bill not to penalize anyone. The intent of this bill is to say, we still want to work with you. We're not trying to be, kicking you out of our right of way. You're an important partner here. Our citizens need the services that you provide. One of the other pieces to this, beyond just the capital projects, is also sort of the cleanup of abandoned facilities. So as anyone who's in private business can understand, when you're doing something and you're making money off of it, it makes sense for you to keep it up, maintain it, ensure it's in good working order. If at the end of the useful life of that facility, you no longer need it, but you're not making money off of it, you're probably not in a big hurry to run out there and take it down or clean it up or make it look nice. Well, one of the concerns that I have is that that's not being done, and so it's leading to our citizens being forced to see, some of these poles, what they call double wood poles, where you've got multiple utility poles sistered up next to one another, or things that are left unattended to, or lines that might be coiled on the ground or coiled up in the air, but they're interfering with people's ability to kind of use the area next to the pole. These are issues that I've legitimately had constituents reach out to me and talk about, and it's what put it on my radar to fix that. So ultimately, again, this is a good partner bill. We want to reach out to the utilities and ask for them to do these things, but when you're not listening, or you're ignoring us, or you're choosing not to do the things that we're asking you to do as a good partner, then at that point, we need to have something that we're able to step in with and say, then this is what we're going to do. And that's what this bill does. So again, I would ask for all of your support. I recognize that there are some concerns about this because this is new, but to me, I view this as a good way to spend people's money. The taxpayers are coming to us and they're asking us to be good stewards of their money. That's what this bill does.
Ms. Hare.
Thank you, Madam Chairwoman. Mr. Phipps, I think perhaps this question is for you, and I don't know that this bill actually changes this, but I'm just curious for my own understanding. With the notice, how is it that we are providing notice to the utilities if this project is coming down the pipeline? Do we give them notice 3 months in advance before we want them to move it, a month in advance? Is it email? Is it a certified mail? How do we do that?
Chris Phipps, Director of Public Works. So it is a long process, and we try to start with sharing information. So at the 30% design phase, one of the first things we do is send our plans out to the utility companies to gain information from them about what we're proposing to do and where they have utilities in the vicinity, and can they provide us information that we can then market. And then that process continues as we refine design to a point where hopefully, if we're all working together, we have identified the actual conflicts and we can work with the utility companies to clear those utilities in advance. And typically it's BGE first, because often they own the poles. They'll clear, and they have the highest utility, the electric lines. They'll move their poles back to where they need to be outside the conflict zone, and then Verizon and Comcast would follow suit. So, because a lot of times they're all hanging off the same utility pole. So that process, it's long, it's drawn out, as is designed. What we're trying to avoid is that once I have a contractor out there, once I put a spade in the ground, now I'm paying mobilization, that contractor's incurring a lot of costs, and then we encounter problems after the fact because things weren't marked properly, things are encountered that weren't marked at all, they were uncharted, and we run into those conflicts. They need to be addressed. And that's where, we'd still have to work with them to define, because I recognize you can't, 45 days isn't a whole lot of time when you have to design, permit, and construct a relocation. But our goal would be all of that, provided we have all the information and everybody's working from the same set of information, we know all the conflicts. They're immediately apparent to us, and we're not encountering them during construction, because there's nothing more, and I'm sure you know in your practice, there's nothing more costly than encountering the unknowns during construction. So that's what we're trying to avoid.
Okay, so it sounds to me then like it would be unheard of, really, very rarely perhaps, that a BG&E, a Comcast, a Verizon would get their first notification and have only 45 days. It sounds like they're going to know, and they do know far in advance, and then by the time you serve this 45-day notice, they've been expecting it for quite some time.
Right. That all the due diligence, good faith efforts, if all that is happening, then we're working together and there's no need to send a 45-day cure notice. It's only if they're unresponsive, not working with us. and all other attempts to productively work on this fail, and as Councilman Volke says, the public is incurring these costs, we need to compel the relocation. And this is, we feel, a tool to help us do that.
Okay, thank you.
Seeing no other comments from my colleagues, we'll now open the public hearing on Bill number 220. Remarks will be limited to 2 minutes. I do have an individual signed up, Mr. David Wright. Your name and address, and you have 2 minutes, Mr. Wright.
Of course. Good evening, Council. David Wright, 619 Puritan Court, Annapolis, on behalf of Baltimore Gas and Electric Company. With the understanding that there are some amendments proposed, BGE is currently opposed to 220 as written, really from two primary standpoints. One is that 45-day time frame, as Mr. Phipps just mentioned, that it is a very short period of time, so we can see instances where we could get a notice, perhaps even without this collaborative effort, and be required to move some facility within 45 days. As you can imagine, all of our projects take some degree of engineering, permitting, design, procurement, sourcing, scheduling, and actual construction. And just in permitting and design alone, that can take up to 120 days each with very little concurrence. So it would be very difficult for us to meet that 45-day requirement. And kind of the penalty aspects of this bill is the suspension of active permits and kind of the delay of permits and issuance. So given that 45 days being very difficult for us to meet, we'd be at great risk for not being able to legally operate or maintain our system countywide with the suspension of those permits. So we have great concern about that. The second real troubling aspect for us is the kind of the premise of the county or some of its agents going out and dealing with what is perceived to be abandoned underground utilities. Our crews are trained, qualified, and equipped specifically for working with underground gas and electric equipment, right? And so somebody going out there without that same sort of skill and equipment, I think really puts those workers at some risk, and the community in the nearby vicinity in the same. Just, you know, we have some very critical stuff underground, and we don't want to see anyone get hurt. So I thank you for your time.
Madam Chair.
Thank you. Mr. Volke.
Thank you. Mr. Wright, couple questions. So I understand your concern about not necessarily qualified people working on your equipment and the concern that that would pose. Major problem. Frankly, I don't know that the county would undertake it, because since we self-insure, if we move it and we cause a big problem, you all are probably going to be knocking on our door with a lawsuit. So I think that that's probably why the penalty component of this is more likely to happen than the county going out and undertaking the duty of moving the equipment itself.
Sure.
So I think that's one issue. But the question that I was going to ask you is on the 45 days. So I understand your concern. I understand the permitting period. Would BGE, if this was moved to a 120-day period, for instance, now be supportive of this bill?
So I knew that question was going to be asked. You know, what is the magic number?
Right.
You know, the difficulty there is that an obstructing utility can take on any you know, any forms or fashions. It could be a single gas service that we could turn around in a very short order of time, or it could be, you know, a 24 kVA underground electric line that takes a great deal of effort to design and construct. I think I would be hard pressed to find anyone internal to the company to sign up to a number, and if they did, I think it would be such a large number that it certainly wouldn't be of any use or interest to the council and the legislation.
May I ask a follow-up, Madam Chair?
Yes.
Thank you. So, Mr. Wright, I understand that. I get that. Do you agree with Mr. Phipps when he was talking about the design phase and how the county typically gives their plans to BGE and they start to look for these obstructions or problems in the right-of-way very early on? Because I get your point, and I understand it, but from what I'm hearing from the county, it sounds like DPW is trying to do the legwork on the front end to find where these problems are so that we're really not running into this down the road, and it sounds like it's more of a last resort than, hey, this is the first time that you've heard that we're doing this project, you have 45 days to move your stuff.
That certainly is an element of all design, and we do the same thing internally when we design a job. You know, the first thing you do is you go out and you pull obstruction data, county records, city records, and find out, you know, what things supposedly lie in the ground and try to design around that. So I'm certain that that is happening to a degree. But just simply reading the legislation as written, I can see an instance where our first notice could in fact be just some sort of formal notice from the county saying, hey, we found something in the ground, you're on the clock.
So tell me what that would look like.
With regards to...
Because I'm going to ask Mr. Phipps the same thing when he comes back up to say, you know, what would you do in this scenario? So if you envision a scenario where your first notice is 45 days, what does that scenario look like? Because then I'm going to ask Mr. Phipps, what does that 45-day scenario look like from the county standpoint to try to figure out if everybody's agreeing that in fact maybe this 45-day window is too short, or they see it a little bit differently. Hopefully that bought some time for you to think on that.
Well, I would suspect we'd take sort of a dual path. One is that we would issue an emergency job and just start that in process, but at the same time, reach out to Department of Public Works or whomever encountered that and just try to kind of resolve that.
Well, I guess more what I'm thinking is, so for these large-scale public infrastructure projects, it sounds like from what Mr. Phipps was saying, DPW is months, if not years in advance, coming to BGE, Comcast, Verizon, other utilities, Broadstripe, whoever it may be, saying, this is where we look like we're running. So you're having all that time in terms of lead and notice, if you will, to make these changes to your infrastructure, your apparatus. What scenario do you envision where the first notice you would get, I mean, it sounds like it would not be on one of these big projects, so the first notice that you would get would say, hey, you all were unaware completely that we were doing anything here, but you have 45 days to move this.
So the other scenario that I could envision, and I've seen this happen based upon, you know, I have some experience in utility construction myself, is that when a project is underway, there are always certain field conditions that can cause anyone to stray from a plan, right, and have to shift a couple feet in either direction, widen a road, narrow it, what have you. At that point, once that job is actually in construction, those sorts of necessary field changes could then put a piece of utility in obstruction to the necessary plan. So that would put us on the clock, certainly, and again, be very problematic.
I think that's fair. I'm going to ask Mr. Phipps when he comes back what his thoughts would be on that.
Of course, thank you.
So, thank you.
Thank you.
Thank you, Mr. Wright. I don't have anyone else signed up from the public to speak on Bill number 220. Is there anyone else in the audience? Last call. I'm going to close the public hearing then, seeing no movement on Bill number 220. Madam Secretary, please read the title of Bill number 220.
Bill number 220, an ordinance concerning public works, roads, and rights-of-way, obstructions, abandonment of facilities.
I believe Mr. Volke has some further questions. So, Mr. Volke, you have the floor.
Thank you, Madam Chair. You know, it's funny, I'll make this comment. I was listening to something that talked about the difference between a cynic and a skeptic. A cynic, you can never change their mind. A skeptic, once you answer their question, sometimes they will change their mind. So I'm trying to be more skeptical than cynical on this. So, Mr. Phipps, if you can just sort of answer the same line of questioning, I guess, that I was asking Mr. Wright about, his indication of possibly what sounds like a change order, more or less, when you're in the middle of a project where scope changes or, you know, the feasibility of the project shifts and now you've got to do it a different way. Do you envision this 45-day clock kicking in and you immediately putting the utility on the clock and saying, move this or else?
I don't envision that. I would say that we're kind of back to that collaborative process, because I recognize that this is difficult work, and when you're running into those types of unknowns, it's going to take time to readjust and get it right, because, you know, last thing we want to do is hurry it, and, you know, haste makes waste, and then they put it in the wrong location, and then we create another conflict. So, in my mind, that starts a new collaborative process that, if that's not carried out with due diligence and good faith efforts, then eventually we'd get back to the same point of, okay, it's time to issue a 45-day cure notice.
Okay, and so I appreciate that, and I think that's helpful to understand the county's perspective on this, and that makes sense while you're in that chair running the Department of Public Works, and that's your perspective. If someone came in who was a very strict rule follower, potentially they could change that, which I can see is the utilities concern. Do you think there's anything that we could do that would alleviate that at all, to where they would feel comfortable that you're not immediately going to throw the book at them and the 45 days starts on some sort of a change order like that?
First of all, I'd like to clarify, I am a rule follower.
Oh. Sorry, Mr. Phipps. Apologies.
Check the record.
Run it back.
I think, that's something I would have to defer to Pete if there's any consideration.
We'd be, if there's language, I'm not quite sure how you would do that. But be open to somebody smarter than me coming up with.
Ms. Shewitt, she's on it.
Cool.
Oh, you said I was smarter than him in public.
And I'm agreeing.
Sorry.
Ms. Hare?
Thank you, Madam Chairman. I was just going to throw out an idea because, Mr. Phipps, you've used the word cure notice a number of times, which is something we use quite frequently sort of in the federal contracting. And I'm wondering if there's a way to work that term into here such that it makes it very clear that this is a notice that's being given to cure a problem, which suggests that there have been multiple attempts to already collaboratively work it out that have failed. At least that's how we see it federally, and I'm wondering if maybe there's a way to work that into this.
Be open to, I'm not sure. Again, I'm not sure about the term cure, but open to that concept of finding a way to do it without watering down the bill so much that it has no impact.
There are currently 2 amendments. If we wanted to proceed with amendments, Madam Secretary, please read amendment number 1.
Amendment number 1, this amendment strikes the term calendar from the bill as superfluous due to existing code provisions for computing time.
Is there a motion to adopt?
So moved.
Is there a second?
Second.
This is Ms. Lacey's amendment.
Thank you, Madam Chair. This does something very simple, removing superfluous instances of calendar. I could have put in one calendar, but it's more clear to actually take out all those instances since we know how days are defined in the code.
Does the administration have any response?
We support.
Is there any discussion from my colleagues? Madam Secretary, please call the roll on amendment number 1.
Ms. Hare?
Aye.
Ms. Lacey?
Aye.
Mr. Volkey?
Aye.
Mr. Krusky?
Aye.
Ms. Fiedler?
Aye.
Ms. Rodvian?
Aye.
Ms. Pickard?
Aye.
7 in the affirmative, none in the negative. Amendment number 1 is adopted.
Madam Secretary, please read amendment number 2.
Amendment number 2, this amendment makes the collection of costs of county removal of abandoned facilities mandatory.
Is there a motion to adopt?
So moved.
Is there a second?
Second.
Ms. Lacey, this is also your amendment.
I think it just makes sense. CENTS as well as dollars.
Does the administration have a response?
Administration supports.
Is there any? Mr. Volkey?
Thank you. So, as I understand it, this will take the discretion out of the director on the recoupment of cost and make this a requirement that the county go after costs if there's a moving of facilities. Is that right?
That's correct. And this gets to Mr. Wright's point, too, that if it's a power utility that's buried, we're not going near that. I'm not going to have anybody in the county in anywhere close. So that's, if they continue to refuse to relocate or remove it, it's abandoned. We don't know it's abandoned until they come out and confirm it and test it, and then they can gladly move it. We're not going to. If they don't, then we go to the civil fine. Now, we just had, and I shared, I think, with Ms. Chairwoman Pickard earlier, that there was a photo of a pit that had just a labyrinth of cables and lines that nobody knew existed. And this was on the Pasadena Road project. It's in the project files. And we worked with, we finally were able to work with Comcast to identify what was abandoned and what wasn't active. And we got their authorization that we could remove it. So we went ahead and did that. Now, that was just part of the project costs that our contractor incurred, but it was safe. It wasn't something that we were putting anyone at risk.
Okay.
So in this case, we'd be able to recover those costs. We would recover those costs if we incurred the expense of removing
And so
that.
but what's the benefit of taking the discretion away from you to decide when is appropriate and when's not? I guess that's my question.
It's an abandoned facility that is in the way, so per the code here, it has to be removed. So if it's decided it must be removed, then this gives I don't have the discretion anymore. If we move it, then we should get reimbursed from the contract, or from the vendor, utility company.
I get that, but you can already get reimbursed with may language. The shall language simply makes it mandatory. I guess that's my question. What's the thought process there? Why take the discretion out of it? I mean, if you went in and you saw there was a situation where it didn't warrant going after the fees and you thought this isn't really fair, you've lost any discretion to choose to go after fees or not.
Well, if we've identified it as a conflict and it's impeding our project, and that's the discretion there, that it has been identified and that's a decision we've made, then I think it's only appropriate. I don't know that you'd want to have the discretion for the director to decide when to seek recovery or not. I think.
Well, we had it in the original bill. I guess that's my question. You had discretion in the original bill. Now we're changing it. And I guess I'm just trying to understand why this didn't come up in the original bill.
Well, that's why it's an amendment that we support.
I got that.
Yeah. I mean,
okay.
It's perfecting the original bill.
Okay.
Ms. Hare.
Thank you, Madam Chairwoman. So I'm trying to envision, in the instance where you said the contractor removed this as part of their scope of work, did the county have to pay a change order or pay out extra for that?
I doubt it. I think they probably just, because it was a small section of line that was already exposed. So I don't know how, I mean, I have to go back in the project files to see if in fact it was a significant enough amount or it was just, part of his duties for that day. But it wouldn't have been, if it were a change order, then we would have obviously paid him to do the work.
Okay. Can you envision a situation where you might not want to charge for removal of abandoned facilities? If you find a line, I don't know, it's 20 years old, nobody knew it was there. Can you come up with a circumstance where you might want the discretion, or can you not think of anything along those lines?
No, I mean, we may make the decision not to have to remove it, that it can stay entombed because it's not affecting or impeding the completion of the project. These are where we've determined that it is in fact a conflict. Although it's abandoned, it needs to be removed. And if attempts to get the utility vendor to do it fail, then we can go in and do it ourselves and seek reimbursement.
Okay, so you would prefer the mandatory nature?
Yes.
Okay, thank you.
Ms. Lacey.
Thank you, Madam Chair. Just to add, I think a situation where you maybe couldn't collect, I mean, the intent of this language is to make it mandatory to at least attempt to collect, but if you have something that's been abandoned and for a long time and nobody can seem to figure out where it came from or how it got there or who currently would own it, then you might not have anybody from whom to collect if you couldn't identify them. Is at least that's how I read this. Do you read it that way?
Well, that's possible.
It's not likely, I think, but
it's possible.
So, well, I don't have anything else to ask. Thanks.
Seeing no other questions, Madam Secretary, please call the roll on amendment number 2.
Ms. Hare?
Aye.
Ms. Lacey?
Aye.
Mr. Volkey?
Nay.
Mr. Pruski?
Aye.
Ms. Fiedler?
Aye.
Ms. Rodvian?
Aye.
Ms. Pickard?
Aye.
6 in the affirmative, 1 in the negative. Amendment number 2 is adopted.
Bill number 220, as amended, will be heard on February 18th at our next meeting. Madam Secretary, please read the title of Bill number 320.
Bill number 320, an ordinance concerning Public Works, Coriander Place, Gingerville, water petition, excess front foot benefit assessment.
This is an administration bill. Mr. Barron?
Good evening. Again, Pete Barron for the administration. Joining me is Ms. Henry and Ms. Cooey from DPW and Ms. Kenny from Office of Law. I believe we discussed this bill at the work session. Coriander Place, Gingerville residents have requested that the county extend public water sewer service to their community. Because of the existing maximum front foot rate of $8.65, it's below the estimated cost of extending water. This bill will approve a maximum front foot rate of $13.54 per linear foot, or the front foot, to ensure this project is self-sustaining. 15 properties are affected by the petition. 12 responded, 3 did not respond. 9 property owners voted to support the special rate. 3 voted against it. 7 votes were needed for a majority of 51%. If the council approves the $13.54 assessment, then the project will go forward. Gingerville is in Council District 6. With that, asking to move the bill, and happy to answer any questions.
Do you have any questions of my colleagues? Seeing none, we'll now open the public hearing. Remarks will be limited to 2 minutes. I do not have anyone signed up on this bill. Does anyone in the audience wish to speak on Bill number 320? Seeing no movement, we're going to close the public hearing on Bill number 320. Madam Secretary, please read the title of Bill number 320.
Bill number 320, an ordinance concerning Public Works, Coriander Place, Gingerville, water petition, excess front foot benefit assessment.
Is there any further discussion? Ms. Hare.
Oh, nope, sorry, ready to vote.
Oh, good. Madam Secretary, please call the roll on Bill number 320.
Ms. Hare?
Aye.
Ms. Lacy?
Aye.
Mr. Volkey?
Aye.
Mr. Pruski?
Aye.
Ms. Fiedler?
Aye.
Ms. Rodvian?
Aye.
Ms. Pickard?
Aye.
7 in the affirmative, none in the negative. Bill number 320 is passed.
Mr. Volkey.
Motion to adjourn.
Second?
I have a script. Is there any other business to be brought before the county council this evening? May I have a motion to adjourn?
So moved.
Is there a second?
Second.
All in favor?
Aye.
Opposed? Motion carries. The county council is adjourned until February 18th, 2020.